Weekly list old matter item number 1.
The public information officer of Lokpad office is the appellant before a lordship against the order of the second appellate tribunal, allowing the directing us to supply the information to the applicant. Although it is barred under section 12(5) of the Act, that is the only case. Both the courts below, the PIO and the first appellate authority, they rejected that you are not entitled to get the information. But the second appellate authority reversed both the orders on the ground that you are. The investigation is going on. The law says that the final result will be intimated to supply to the applicant. Now, the proceeding by virtue of this order, I have to we are now directed by the authority, second appellate authority, to provide the information. This is not a
2010 writ petition, sir.
Yes, that is the only thing, that it is a case of 2010.
Yes.
Now it is
all infractuous, sir.
Yes, my lord. Since 12 years, my lord, investigation had completed. I think it is not correct.
Yes. Due to long passage of the and with there being no interim order passed with this court in the last 12 years of pendency of the present petition, the court is not inclined to interfere. The petition is accordingly dismissed.
My name may be different.
All right.
Old matter item number 2.
Lordship directed me last occasion to file an affidavit specifically stating what is the up-to-date license fee remaining outstanding against the petitioner. I am ready with the affidavit and I have served copy on the other side on the last evening. Yesterday, but the outstanding amount is clearly mentioned 40,000. Lordship, may kindly see order dated 27/7, last order, your lordships, July.
Are you prepared to pay this? Are you prepared to pay this sum, sir?
My lord, I'll take instruction because yesterday night I got the.
All right. Counsel for the petitioner states that he has to take instruction on the affidavit filed today by the BDA.
Yes.
Pointing out that the outstanding license fee in respect of shop KXS-54 in the Kalyani Market Complex is 11,40,519.
Yes, ma'am.
At his request, list on 31st.
Much grateful, your lordship.
Old matter item number 3.
Item 3, my lord. I request your lordship to kindly take up this matter after lunch, my lord.
All right.
May I pray one thing? In this particular matter, FCI impugned order is the Annexure 7. FCI has not filed counter till 8.
It's a 2013 matter, sir.
Yes, my lord, yes. I am appearing for a state warehouse and corporation. I am not for FCI, my lord. I also filed my counter also in this matter.
My lord, on the previous occasion also, the pilot's counter.
No. So you had sought time for instructions last time, Mr. Dash.
But yes, already filed my counter. In respect of yes. Last occasion I have not filed my counter. That is I requested for instruction.
When did you file counter or this one?
But yes, I filed my counter.
Where is this counter?
1910-22 I filed. I think in the record. I filed in the box. Registry I filed.
Orissa State Warehousing Corporation.
1 and 2.
19th is...
I also saw copy to my learned friend also.
Yes, my lord. I've received the copy, my lord.
The copy has not come on record. We'll pass it over. Ask him to bring it on record. Pass over. It might come up before lunch also. Kindly ask the counsel to be ready.
My lord.
Pass over. Correct.
My lord.
Item number 4.
My lord, item number 4 and 5, both are public interest litigations. There was another case, that is WPC PIL number 7284 of 2015, which was unfortunately dismissed for default, and a CMAPL number 235 of 2021, is present for restoration. My lord, my request, my prayer is that all these three cases may come together, and actually these are all similar things and are covered by the judgment of this honorable court, earlier rendered by this the division bench of this honorable court, headed by Honorable Justice Mr. Devagowda. Gopal sorry, my lord. sorry.
Yes.
That is WPC 7284 of 2015,
What
along with the
about-
CMAPL,
Sir, what is the matter about? Tell us.
actually regarding the insurance claim, agricultural insurance claim.
What is it about? Tell us.
The short question is that they calculated the loss basing on the block level. And earlier it was decided by this honorable court that is to be calculated on the basis of panchayat.
All right.
And the collector is to make a public hearing.
Right. Sir, these are all events that happened in 2015.
14, due to
Ah.
filing, actually,
In 2022, what relief can you be granted?
actually we are deprived of the insurance claims
That is
compensation.
fine. But in 8 years, will there be any evidence? Who will go? Who will inquire? Who will find out? What is the evidence to determine crop loss of 2014 and 2022?
Actually, we tried our best to get the matter listed.
Really, sir? Are you honest? You want to be honest about it?
Yes, my lord. No, we
Honestly,
tried
tell me, did you mention this in the last 22 months? I have been a Chief Justice here for 22 months. Honestly, tell me. Did you ever mention?
we
Honest answer is no. Correct?
before your lordship.
Honest answer is no.
Yes, my lord.
So let's leave it at that. So tell me, in 2014, crop loss, in 2022, how will you find out?
The matter may be just, I want that the matter may be referred to the collector.
For what will the collector do, sir? You imagine yourself to be the collector. You get an order from the High Court. Sir, determine the crop loss of 2014. What will you do as collector?
Now they have got the report. If they will just calculate
Calculate what?
panchayat level, if they will just verify the reports regarding the panchayats,
What
things will be
reports,
different.
sir? What reports? Where are the reports?
They have got the reports.
Who's they? And what reports?
Annexure 2 series, crop cutting experiments.
These are experiments, sir. Crop
Ah.
cutting experiments.
They have cutting experiments.
What is a crop loss? You're asking for insurance claim for crop loss.
Now, the only point is that when the loss is calculated on the basis of the block level, the result is something different. And when it will be on the basis of the panchayat level,
These kind
the
of matters,
result-
they are not immediately dealt with. They will be impossible to be dealt. If you come after 8 years and 9 years after the actual crop loss and say, now determine my crop loss, it's going to be impossible. You'll only be going around in circles.
The existing papers, the materials available with them,
What
They-
papers, sir? Tell us which papers.
that is the crop cutting experiments annexure 2 series.
This is not the loss of crops, sir.
That's so. The annexure 2 series shows that this is the loss at the level of the block level,
What is Annexure 2 series shows? Tell us.
4269.
What is it? Have you approached the collector at that time? Did you
Yes.
file a representation?
Yes, we have approached the collector at that time.
What is that
Collector,
to show?
Tahsildar.
What is that to show that?
Annexure 4, copy of the representation.
All right. For what it's worth, we'll ask them to look into it. That's all we can do. You see, the petitioner's representations at Annexure 4 series will be examined by the collector. And after giving a hearing to the petitioners and examining the records, appropriate order, reasoned order should be passed within a period of 4 months. And in any event, Not later than 1st March 2023. The court clarifies it is not expressed in the matter. Same order in that 7285. No, only one petitioner is there in the first one. The second one, I think. Yeah, representation, but petitioner is only one. So they have to hear only the petitioner.
Quick list item number 6.
My lord, that is the third one I want to say, but a restoration matter that is waiting.
Whenever it comes up, we'll see, sir. Same order will be passed in that.
Item number 6.
In item number 6. In item number 6, there are 2 writ appeals. My lord, there is a defect. I don't say that is a defect. Your lordship may kindly see there is a noting that AD is not back from respondent number 4 in both the cases. Respondent number 4 is the governing board. Here, my lord, the question is relating to intercessionarity. So presence of governing body is a must.
My lord, I am for the appellant.
Yes.
My lord, this is only sole point of law is involved, my lord. Both appellant and respondent join in one day, my lord. My lord, this learned single judge nullified the court order of the director and the education tribunal only on the ground that on basis of merit in the select list, the seniority has to be calculated. They have calculated the seniority since both have joined in one day. The date of birth is the criteria. On basis of date of birth, I should have been declared a senior. That has been done by the education tribunal and also the director by law, who is the approving authority. Today also I am filing an affidavit regarding availability of executive instruction to determination of seniority. Single judge has held that in absence of any document, any instruction, the seniority will be calculated on basis of merit. That is the findings. I am filing today the affidavit.
He has not been served.
In the course of today filing, my lord. Lords may see. Lords may see the findings of the court will.
Let him serve a copy.
Oh, sorry.
My lord, I am questioning the maintainability of
Let
this
me submit,
appeal.
my lord. This is my case. He is interfering in every moment. Let him sit. Okay. Well, let's come to the findings of the court, the learned single judge. Page 41, my lord. Starts from page 41. There is no statutory rule administrative instruction, my lord. Internal page 19.
The instruction is very clear, sir.
My lord,
My lord, instruction is relating to.
my lord, that is very clear.
My lord, the instruction which my lord, my learned friend has produced today, this is relating to teachers and this is relating to non-teaching staff. So far as the appellant and the respondent number 1 is concerned, they are peons, they are not teachers. So this circular is not applicable. And there is no circular or executive instruction.
My lord, let me submit.
The question was put
I
to me.
complete my submission, my lord. Thereafter,
I have asked him a question. Let me answer.
My lord, so far as non-teaching staffs are concerned, there is no executive instruction. There is no circular of the state government relating to determination of intercessionarity. Here, what has happened, my lord? An advertisement was floated, and pursuant to the advertisement, the appellant, the respondent number 1, and appeared in that interview. 3 peons were selected, and since one Kulamani Rao, he secured highest marks, he was appointed against the post of first peon. And so far as the respondent number 1 is concerned, he was Basanta Varik, he was appointed against the post of second peon. And so far as the appellant is concerned, he was appointed against the post of third peon. But the director, without taking into consideration the select list, and your lordship knows that there are catena of decisions of the Honorable Apex Court where selection process has been adhered to, or there is an advertisement and selection process is there. So the seniority will be determined on the basis of the position in the seniority list. Here, admittedly, all these three and others also joined on the same date, and appointment orders were also issued in one date. So therefore, the governing body of the college determined respondent number 1 as holder of the second post, one Kulamani Rao as holder of the first post. And so far as the appellant is concerned, he was declared as holder of the third post. And my lord, what the director did, director, as per the government instruction of 1983, his case before this honorable court was, he filed a writ application in this honorable court. In that case, he took a plea that I was prevented to discharge my duties, which tantamounts to termination of my service. As per government instruction of 1983, there is an appeal provision before the director. So this honorable court, I will take your lordships to that order. This honorable court specifically directed to dispose of his appeal. So director, instead of deciding the question of validity of his termination or prevention, decided the question of seniority, which is without jurisdiction, and therefore this honorable single judge has held, my lord, so far as the decision of the director to declare the appellant as holder of the second post on the basis of date of birth, that is beyond competence, beyond jurisdiction. And if date of birth is taken into account, assuming for the sake of argument, Kulamani Rao, who is the holder first post, my lord, he is junior most so far as age is concerned. But on the basis of selection, he was appointed against the first post. He is not challenging his selection or appointment against the first post. He has been approved against the first post. And so far as only he is questioning my appointment or approval against the second post by saying that he is senior in age. That aspect has also been taken into consideration by the learned single judge. Now, my lord, apart from all these things, I am raising the question of maintainability. Your lordship knows that after section 100A was introduced in CPC by way of an amendment in 2002, my lord, this, so far as the second matter is concerned, that is WA number 534 of 2016, that arises out of FAO number 183 of 2011. Because the judgment was passed by the State Education Tribunal, I filed first appeal, FAO, before this honorable court against the judgment of the honorable single judge, my lord, in that FAO number 183.
What was the writ petition about? There is also a writ petition with an FAO.
Yes, analogous hearing was made, a common order was passed.
Why was a separate writ petition filed?
Separate writ petition filed challenging the order of the director, where the director decided that he is the holder of the first post, he is the holder of the second post, and I am the holder of the third post on the basis of the date of birth.
So you filed the writ petition?
I filed the writ application.
And FAO also you filed?
FAO also I filed.
What is the need for FAO against the order of the tribunal?
Order of the tribunal, because, my lord, when my approval, initially I was approved against the second post. My approval, then when my approval was withdrawn, I approached this honorable court. This honorable court said that you approach the State Education Tribunal under section 24B of the Orissa Education Act. I filed a grantinate case before the State Education Tribunal. The State Education Tribunal, relying upon the judgment of relying upon the order of the director, said that that director has correctly decided and accordingly dismissed my GIA. Against that, I filed first appeal before this honorable court. Now, your lordship may kindly see the judgment of the full bench and
no, but still writ appeal will be maintainable as far as the OJC is concerned.
OJC is concerned, writ appeal is, so far as the director's order is concerned. So far as the judgment of the State Education Tribunal, both are interlinked. Since the judgment of the State Education Tribunal is concerned, so far as the judgment of the State Education Tribunal is concerned, writ appeal is not maintainable. Because, my lord, the order
No, no,
passed
so
in the first.
you challenged the director's order in two parallel proceedings, is it?
No.
Ah,
That order I challenged by filing a writ application. And judgment of the State Education Tribunal I challenged by filing
no,
appeal.
but why did you go to the tribunal?
Well, tribunal because when my appointment was approved against the second post and basing upon the order of the director, subsequently it was withdrawn. So at that juncture, I filed a writ application here. So this honorable court held.
So the second matter before the tribunal was only whether you should be appointed against the second post or third post.
But no, the tribunal has held, the tribunal has rejected my GI case basing upon the order of the director.
Oh, I see. All right.
My lord, now your lordship may kindly see the judgment
What maintainability?
regarding maintainability.
So that's only as far as the second matter is concerned.
So far as second matter is
No,
concerned.
but what will happen? Suppose we dismiss the second writ appeal saying it is not maintainable. So you'll have one order of the FAO, single judge in the FAO, which is common to FAO and OJC.
Yes.
That order will be upheld. And
That order
suppose
will be
theoretically we allow his writ appeal in the first matter,
Yes.
then what happens? We'll be contradicting ourselves.
My lord, so far as the writ application against which this writ appeal has arisen, my submission before your lordship is, now your lordship may kindly see the order of the director. 533. Okay. 533 is the period of the honorable speech. My lord may kindly see the order of the director. Your lordship may kindly see the order of the director. Your lordship may kindly see first his writ appeal, why he went before the director. Again. 533. My lord may kindly come. Kindly come to page 5 of the writ appeal. Well, the genesis of the dispute which went before the director starts from here. He filed a writ application before this honorable court, that OJC number 14919 of 1999. He has quoted the order of the honorable single judge at page 5. The petitioner, who is at present working as peon in a +2 college, that is PBM Mahavidyalaya Mahabir Road in the district of Dhenkanal, has approached this court seeking for issuance of a direction the opposite parties to approve his post. However, it has been averred, this is most important, in the writ application that the authorities are now preventing him from discharging his duties, prohibiting an employee to discharge his duties, termination of his services, and according to the circular of the government, appeal lies before the Director Secondary Education. The petitioner, in fact, has filed a representation before the Director on 6/3/1998 under Annexure 8. It is specifically averred that the said representation is pending till today before the Director. After hearing the learned additional government advocate, I feel that no useful purpose would be served in admitting the writ application. Accordingly, the writ petition is disposed of with a direction that the Director, Higher Education, opposite party number shall treat the representation filed Annexure 8 as an appeal, and after issuing notice to the persons to be affected, dispose of the same within a period of 3 months from the date of communication of this order. However, it is made clear that while disposing of the appeal, the Director shall look into the documents produced by the petitioner as well as the annexures filed in this writ application. My lord, now your lordship may kindly come to Annexure 7.
Yes.
Annexure 7, that is. Yes. My lord, page 90. That is not legible. Your lordship may.
So on date of birth, he has made him senior.
Yes. My lord, on date of birth, my first point challenging the order of the director is the director lacks jurisdiction to decide the question of, my lord, inter se seniority, because as per the government circular dated of 1983, he is supposed to decide the list relating to termination of service. Your lordship may kindly see the government instruction.
No. But once the court permits the representation to be considered by the director, and the representation that he should be given the second post and not the third.
No. In the representation, his entire allegation was that I was prevented to discharge my duties, which tantamounts to termination of service. And there are catena of decisions of this honorable court that if an employee is prevented to discharge his duties, it amounts to termination. So, my lord, as per 83 circular, 83 government instruction, your lordship may kindly see the education manual. That instruction is there. It is new book as page 1088. हजार 1080 new book.
All right. Yes. Yes, sir.
Yes. My lord, I am directed to say that it has been brought to the notice of the government in some private unaided educational institutions. The service of the employees are being terminated arbitrarily without assigning sufficient reasons and following the principles of natural justice. Such employees are not entitled to get protection under the Orissa Education Act 69 and the rules made thereunder. The teachers of aided educational institutions only right of appeal before the State Education Tribunal under subsection 3 of section 10A of the Orissa Education Act 69. Though the employees of unaided recognized private educational institutions do not have any statutory right of appeal before any authority, government feel that illegal termination of service in unaided recognized private educational institutions should be stopped. It has therefore been decided by government that if an employee of any unaided recognized private educational institution feels that his services have been terminated arbitrarily, he may file an appeal before the Director of Public Instruction, HE Odisha, in case of employees of unaided recognized private colleges. That means the director, because subsequently the nomenclature of the Director of Public Instruction has been changed as Director Higher Education within a period of 1 month from the date of termination. So the director was supposed to decide the question of termination or prevention of his.
No, but this is an incidental question.
Yes.
Suppose he feels that because of the date of birth, this man is entitled to that second post.
Yes. My lord, now, my lord, if your lordship says that the director has decided the matter basing upon the date of birth, my lord, here, my lord, all these 3 peons were appointed on one date pursuant to a selection process. Your lordship, I see that document. The director simply said, well, your lordship may kindly see the findings of the director. The director has not taken into consideration the select list, or he has not come to a findings that the select list which is available with the governing body or which is available in the college, that is a fraudulent one. Your lordship may kindly see the select list. My counter. Your lordship may kindly see my counter annexure B/1 at page 14. Select list of B/1.
So Kulamani Raut is first.
Yes, your lordship may kindly see. So far as Your Lordship may kindly, Annexure B by 1, this Kulamani Raul or Raut, Your Lordship may kindly see what is his date of birth. Third column, 15/5/64. Basanta Kumar Barik, myself, respondent number 1, 5/5/64. And Lokanath Barik is the appellant. His date of birth is 17/1/64. My Lord, if, my Lord, this list has been prepared not on the basis of date of birth. This is the select list where, my Lord, even Kulamani Raul, who is junior in age amongst all, he was given appointment against the first post.
And that was not challenged.
That was not challenged. And that is the findings of the learned single judge, saying that if date of birth was the consideration,
Then they should have challenged Kulamani law.
yes, yes. And my Lord, so far as my learned friend who has referred to that circular,
That applies only to teachers, you see.
apply to the teachers. There is no,
All right, let's hear it.
yes.
My lord, I given a date chart. My lord, the already in record, my lord.
The copy there.
My lord, the both, my lord, the time at the time of appointment, the college in question was private. The college made a selection of 7 candidates, lecturers and peons, my lord. In the one day, 3 peons and 5 lecturers were joined. On my lord, what the selection committee is a subcommittee. He given the merit list, my lord. That is only on basis of viva test, my lord. What they have done, my lord, on basis of joining time, they have determined the seniority, my lord. Joining time, I have filed in Annexure 5 series. On basis of joining time, since Kulamani joined first, he was first, then I am second, the respondent third, my lord. Then when this college became eligible to grant in my lord, I approached the Sound Court. Director, on basis of the executive instruction that regarding teachers, my lord, that teachers and all the other staff are guided by that instruction, my lord. Today I have filed, my lord. The director has said that the determination of the seniority has been based on the date of birth, since both have joined in one date, my
The
lord.
circular that you have enclosed with the
My
affidavit
lord,
today-
that circular they have followed since 1985, my lord.
No, for teaching staff, sir.
My lord, teaching and non-teaching also, my
Where do you
lord.
get non-teaching?
My lord, even if we also say that is not applicable, but I have brought a decision to that point, my lord. In the absence of any rule, the date of birth is the only criteria, my lord.
No.
My lord, I will place, my lord. I will place director yourself express any opinion or agitation, my lord.
So you are not allowed to ask
No,
you
no,
a question.
No, I am one thing I place thereafter you may say. Because what they have done, my lord, I conclude in one sentence, my lord. My lord, the governing body not acted upon the date of birth, my lord. They have determined on basis of joining time, my lord. When matter came before the education authority, my lord, tribunal and the director, they have determined on the basis of a date of birth, my lord. That was the subject matter of challenge in FO and the writ application, my lord. If lordship's view is taken into account, my lord, then instruction, my lord. Even if on that basis, my lord, I have brought 3 decisions on this point that is already attached to my date chart, my lord. Lordship got it. I'll provide. I have 1 copy, my lord. Already on record, 3 decisions on this point. In the absence of any rule or instruction,
Well, I have also brought decision of the Honorable Apex Court that where selection is there, selection will prevail over other things. Well, I will bring that also.
my lord, I also judgment of Magila Devel. He has brought 2000 decision that is on basis of written and viva.
Blameless convert. Blameless convert doesn't. Your Lordship, I kindly see that. Where on the basis of
My lord, he is not permitting me to make my submission, my lord. Lord, see,
pursuant to the query
why
made by the
pursuant means
Honorable-
you have all. This is my case.
My Lord,
He is
Your Lordship, I
occupying
kindly
his
see the
time.
judgment.
1 minute, sir.
Why are you being irritated? Why are you being irritated?
My lord,
You have given us the DP Das judgment, right?
my three judgments are there, my lord.
You want to place us, you place us.
My-
Place this. If you
my-
want to get angry and keep sitting
My lord,
down, you do it.
at
Are
every,
you addressing us or are you
My-
addressing him?
my lord, come to that overall judgment, my lord, 2011-2, my lord.
You're not in a good mood to argue, sir? Are you not in a good mood to
Well,
argue?
today I have last night I could not sleep.
Then say that.
That is why.
Counsel for the appellant says that he's not. It's inconvenient for him to argue the case today. The affidavit filed by copy of the affidavit filed by him has been handed over to counsel for the respondent
Yes.
number 1, who says that he will seek actions. At his request, list on
Your lordship may call this matter next week.
28 November.
My lord,
28 November, one
Nice.
small advisor on 27th November, kindly go to
My
sleep
lord,
early.
my-
Ah.
Today I also.
Your bad mood affecting all of us.
My lord,
Ah.
Due to late night,
So kindly sleep well on 27th.
my.
Ah.
Item number 7.
please, your lordship. My lord, the petitioners before my lord are challenging the judgment of the honorable single judge in a proceeding arising out of consolidation matters.
The delay is 203 days.
Miller? The delay, an application I have filed, Miller. In the meantime, the OP number 1 has also died, Miller. I have to take steps for substitution of the.
First, you have to satisfy us first about delays. Sir.
Miller, they have filed an objection to the application, Miller. Lordship may kindly see. Miller, I have filed an application under section 5, Miller. I have taken in paragraph 4, Miller.
Not convincing, sir.
Delay of 8 months, Miller.
Not convincing, sir. There is an extraordinary delay of 203 days. Just put down this MC number 538 of 2017. An extraordinary delay of 203 days in filing this appeal. Stop. A perusal of the application reveals that it took 8 months even to apply for a certified copy of the order dated 30th January 2017. Such an application was made only on 4th September 2017. No satisfactory explanation is forthcoming for the delay in the application. Consequently, the court is not inclined to condone the delay. MC number 538 of 2017 is dismissed. Consequently, the appeal is dismissed.
Weekly list item number 8.
None appeal is dismissed.
Item number 9.
May I please, Your Lord?
My presence may be recorded in item 8.
All right.
Item 9.
Item 8, I have also for OP number 5, respond number 5.
Item 9. May I please, Your Lord? Here the petitioner challenges the promotion of opposite party number 7 under Annexure 7, as well as the virus of the OMC recruitment and promotion rule for non-executive 2012. Here the virus of the rule is that after 4 years of service, regular service in the post of pharmacist, the person who was recruited under the new rules, they are promoted to the senior pharmacist. Whereas petitioner has rendered 29 years of service, he was not given promotion because of the old rule. That Lordship may see the opposite part number 7, who was initially appointed on contractual basis.
It is challenged. You have challenged some Rule 8 of the Odisha Mining Corporation recruitment and promotion rules.
That rule, Lordship may see, both the rules does not support the contractual appointment or ad hoc appointment. Lordship may see the rules. Now, Lordship may see Rule 3.1. I am placing the recruitment rule of
You are
97
appearing for
recruitment.
OMC, is it?
I am appearing.
All right.
3.1. These rules shall apply to matters relating to recruitment and promotion of all the non-executive employees under the administrative control of Orissa Mining Corporation, excluding non-executive belonging to non-permanent, ad hoc, trainee, piecemeal rated weekly, casual and contract categories. Non-executives on deputation from the state government or from the organizations. Now, Lordship may see the cadre of the non-executives, that those who are recruited under the 97 rules, that is page 16. The first one is the HS4, that is the pharmacist post, and the promotional post is HS1. That is page 32, where the qualification has been prescribed, page 32 of the writ petition. Pharmacist direct recruitment, that is HS4, having qualification metric with 2 years training in pharmacy from the government recognized institute of government of Orissa and must have registered his or her name in the Pharmacist Council of Orissa. The next promotional post is senior pharmacist. Now, Lordship may see the promotion criteria. That is page 24, Rule 9.13.16. All promotion to next higher post shall be vacancy based and shall be made at the discretion of the management. There is no time-bound promotion. And now, Lordship may see the new rules. That is 2012 rules. That is at page 41. Starts from 40, that is that rule came into force from 1/10/2012. And page 41, Lordship may see again the clause 3.1. These rules shall be applicable in the matter of recruitment and promotion, and all non-executives to be recruited in accordance with these rules under the administrative control of Odisha Mining Corporation Ltd, excluding non-executive of Odisha Mining Corporation Ltd, appointed, promoted in accordance with R&P rules 1976 and RP rules for non-executive 1997. That means petitioner is not governed by this rule. These are only applicable to the person recruited under these rules. And the Lordship may see the last. Employees appointed on contract basis, these are excluded. Non-executive belonging to non-permanent category, DRMP, ad hoc, trainees, PR mines, weekly, casual or similar category. So these rules are not applicable to this contractual appointments. Now, Lordship may see the promotion criteria. Lordship may turn to page 49. The promotional post is senior pharmacist. Item number 2.
Yes.
That is promotional post. Promotion from among the eligible junior pharmacists with 4 years experience. That means those who are recruited under these new rules, after completion of 4 years of service, they will be promoted to the senior pharmacist. Whereas petitioner recruited under the old rule and continued for last 29 years, they are deprived to get promotion to the post of senior pharmacist. Now, Lordship may see the notified below last notification. The senior pharmacist in higher skilled one may be considered for further promotion to the executive grade E1 as per the provision of R&P rules for executive 2012. That means in 2012, if a person completed 6 years of service in the post of senior pharmacist, he will be again promoted to the post of executives. That is superintendent 1 in 2012. That is R&P rules for executives. That I have also annexed in an additional affidavit. Now, Lordship may see. Page 36, what has happened? Opposite party number 7. There are 5 persons who are recruited in 2006 on contractual basis. That both the rules does not support for contractual appointment, but they are appointed on contractual basis. I am placing the order itself. The services of the following contractual employees now working in different units of OMC Ltd are hereby regularized in the post with corresponding scale of pay and grades as pay and indicated against each with effect from 1/5/13 as per provision of R&P rules for non-executive 2012. They are not recruited under the 2012 rules. D or the rule, they are appointed on contractual basis on 2006. Date of appointment. I am challenging the appointment order of item number 2, that is who is added as party number 7, Lina Priyadarshini. In the second petition, I have challenged all the promotion orders of the 5 pharma employees, that is with 1, 2, 3, 4, and 5. All of them are appointed on contractual basis on 2006. That the Lina Chandra Priyadarshini, he was appointed on 6/3/2006, and he was regularized under the new rules on 1/5/2013, where there is no such provision for regularization. In the new rules, I am again placing the new rules. Not to may see. Lordship, page 46, Rule 7.4. The non-executives recruited prior to implementation of these rules and possessing qualification and experience for any post under these rules may also attend the direct recruitment process whenever recruitment to any post as per these rules is undertaken. In such case, upper age limit may be relaxed up to 10 years. And after appointment, they will be governed under these rules. In 2006, neither they are appointed under the old rules. At that time, the old rule is governing the field. And this in the new rule come into force from 2012. But they are regularized under these rules, new rules, or the provision of the rules. They are neither recruited through any recruitment process, either in the old rule or in the new rules. Now, after 4 years of service, they are further promoted to the post of senior pharmacist, Lordship may see Annexure 7. That is, I am changing. The following pharmacists now working in different units of OMC are hereby promoted to the post of senior pharmacist in class 3 grade in the scale of pay of 9,300 to 34,800 with GP. Lordship may see Annexure 7, page 52. So these 5 persons are again promoted to the post of those who are regularized in 2013. After 4 years, they are promoted to the post of senior pharmacist.
Yes. So what is your grievance?
Now the Lordship may see page 48. That old rule is neither repealed. That is prevailing in the field. Now this rule also is operating in the field. That is the pharmacy. Lordship may see.
How are you aggrieved? What is you're aggrieved by what? What is your grievance, sir?
Lordship may see, I am appointed on Annexure 1, page 90, 12. That is 9, 10, 99, 92. I was appointed as a pharmacist. I am reeling in that same post for last 29 years. I am not getting promotion. But the person who are pretty juniors to me, those who are pretty juniors to me, they are promoted to the post of senior pharmacist, and I will work under them. Now the opposite party number 7 is posted to my hospital where I am working under him. He has just completed 4 years of service. Thereafter, she was promoted to the post of senior pharmacist. So this rule 8.1 as well as the annexure D, for basing on which this promotion order was given. And I have challenged that virus of that rule, that is violative of the Article 14 and 16 of the Constitution of India. Because both the rules are operating in the same cadre and creating two different classes among one homogeneous.
No.
That
so if you
DS
go back to
Nakara
this
case, my lordship.
Office order 11/5/2017, you do not figure in this at all. The office order of 11th May 2017, Annexure 7.
Yes, my lord.
You do not figure in that.
Yes, I have challenged that order.
That's what. Yes.
And they also admitted in their counter the same thing. Only they say that although he was not promoted, but he was given RSCP, that is a assured career progression scheme and a time-bound advancement scale of pay. So he may not claim the promotional post, but RSCP does not give any status to a person. That is not actually a functional promotional post. That is only given a financial assistance to a person because he is not promoted to the next post. And and now, Lordship may see, I have filed 2 affidavits. There now in 2022, they have promoted 11 persons. Those who were appointed on 2017, they are promoted in 2022 after 4 years. Again, applying the new rules. Lordship may see 2 affidavits I have filed. That is, one is 329 of 2022, where 11 persons are promoted. And those who are appointed in 2017, those persons are promoted to the post of senior pharmacist.
All right. Yes, Mr. Mudali.
In fact, your lordship can see the prayer at page 10. The petitioner is challenging the promotion given to the opposite party number 7. I have received the information that the opposite party number 7, she has been removed from the service by the disciplinary authority on 23/6/2021. Thereafter, he preferred appeal. That appeal has been rejected. Now the matter is before the Honorable Court in WPC 16722 of 2022. That person has been removed from the service. And so far as the bias of Rule 8.1 is concerned, your lordship, admittedly the petitioner is governed under the 1997 non-executive rules. And that is a dying cadre. Your lordship may kindly turn to the rule which is impugned here. That starts from page 39. My lord may kindly turn to page 40. That is the office order by which the new rules to 2012 rules came into force. My lord's at page 40.
40.
Yes. Office order as approved by the Board of Directors of so-and-so in its 393rd meeting held on 25/8/2012, OMC recruitment and promotion rules for non-executives 2012, herewith enclosed, hereby comes into effect from 1/10/2012. So this has been given effect to from 1/10/2012.
No, but now, it does not apply to him.
Yes, it is not applied, and you also can see next page.
No, he's also saying this rule doesn't apply to him at all.
If the rule, he's challenging the bias of this rule. On the
He's
ground
also
that,
challenging it, but according to him, this rule also does not apply.
yes. No, he is claiming that this rule should be made applicable to him, so that he will be able to get promotion after 4 years. That is his case. But you also can see page 41. Clause 3, scope and application, 3.1. These rules shall be applicable in the matters of recruitment and promotion of all non-executives.
No, I think you are not understanding from what we understood his argument.
Yes.
By referring to this clause 3,
Yes.
he says these rules do not apply to. That is his case. He does not want these rules to be applied to him. He says these rules do not apply.
No, his claim is that by virtue of this rule, the opposite party number 7, who is much junior to him, she has been given promotion to the post of senior pharmacist much ahead of him. That is his case. So
By applying to her perhaps the new rule.
yes, by applying the rule. So his case,
new rule.
yes, by applying the new rule. So his case is
He says no, those rules don't apply.
no, if so in 1997 rules, the promotional avenue is vacancy based, whereas the promotion avenue in the 2012 rules is otherwise. After completion of 4 years as a junior pharmacist, his case can be considered for promotion. His case is, well, since the opposite party number 7 was recruited under the 2012 rules, and she has been given promotion to the post of senior pharmacist after 4 years of completion of service as a junior pharmacist. So why I have been discriminated, though I have completed more than 25 years, but till date I have not been given promotion to the post of senior pharmacist. So that is why he is claiming that I have been discriminated. That is his case.
That's right. He's been discriminated, but he's saying these rules do not apply to him.
So now he claims that this rule 8.1 should be quashed so that he will be able to get promotion under these rules.
No, amendment is required. Lordship, that is rule 13.
Your
The
Lordship,
OMC recruitment and promotion rule for non-executive 97 shall remain in force for those employees appointed and promoted under the said rules. That
Yes.
means that rule is still continuing along with these rules.
page 10 prayer, my lord, can see.
Again, if they recruit any contractual appointment, they give anybody to contractual appointment, they have to amend provision of 3.1 because the rules is not applicable to the contractual appointment, ad hoc appointment. That was not amended. So initial appointment of opposite party number 7 was on contract basis in the year 2006, and he was regularized in the post of pharmacist in the year 2013 under the new rules. How he was regularized under the new rules? He was not recruited under the new rules. Rule says the person who are recruited under the rules, they will be governed under it, not any other provisions. He was neither recruited under the old rules nor recruited under the new rules. But the board of directors appointed on contractual basis by making a meeting that they abolish the original post and appoint the contractual post. And that was not done in this case. They have to abolish originally the post of regular post of 5 posts. Thereafter, they should appoint the contractual appointment should be given. That was not done. They were whimsically appointed on contractual basis in 2006 and regularized under the new rules in 2013. And thereafter, 4 years, they are given promotion to that opposite party.
So what is the explanation for not giving him promotion?
And now in the second petition, I have challenged all of these 5 persons who are given promotion. Second petition is there.
Our explanation is that though assumed that both the rules are continuing, that the old rules that is the service.
Then you are selectively applying to those appointed like him contractually under the old rules. You have applied the new rules and granted them promotion. How have you left him out?
No. He was appointed under the 1997 rules.
Even opposite party number 7, he says, was appointed in 2006 only.
No, we have explained in our counter affidavit that is not the case.
When was the opposite party number
He
7
was
appointed?
given appointment in the year 2013 on regular basis.
Contractually, when did he enter service? Our opposite party number 7.
On contractual basis in 2006, Lordship may say Annexure 5, page 36. The services of the following contractual employees now working in different units of the OMC Ltd are hereby regularized in the post of with a corresponding scale of pay, as indicated against each, with effect from 1/5/13.
Was also appointed in the year 2006 under the 97 rules on contractual basis.
Well, now that grievance against the opposite party number 7.
But still his grievance remains, right? He's still not regularized. Opposite party number 7 may not have been terminated, he's lost his appeal, all that.
Yes.
His grievance still remains unaddressed.
No.
He anyway should be regularized. That's his case.
His services are regularized. Well, his case is that since under the 2012 rules, the opposite party number 7 has been given promotion to the post of senior pharmacist. So I being the senior, I should
So
have been-
anyway, that grievance remains. He's still not a senior pharmacist. He's still not been given his promotion.
No,
Whether opposite party number 7 is there or not there, his grievance remains.
well, according to his rules, the rules which is applied to the present petitioner.
No, you are selectively. His point is when it comes to him,
Yes.
you point out that he's come under the 97 rules that he can't be promoted.
Yes.
When it comes to the others who are similarly appointed like him, you apply the new rules and you are granting them promotion.
Well, since he was regularized under the new rules, so new rule was made applicable to the opposite part number 7.
Why haven't you regularized him under the new rules? This is question, sir.
No, he has been appointed much in the year 1976 probably.
He is appointed in 92.
92 under the 1976 rules.
Yes.
Thereafter, 1997 rules has been made applicable to the petitioner.
All right.
And in lieu of promotion,
if 97 rules apply to him,
yes,
he should be on the same footing as others appointed under the 97 rules.
In same footing.
No.
Yes.
Others, those 5 persons whom you've granted promotion, Annexure 7.
Yes.
He's on the same footing as they are. They were all junior pharmacists.
Those are all juniors. Lordship may see, those are regularized in 2013, that is Annexure 5. And in Annexure 7, they are promoted after 4 years of regular service to the post of senior pharmacist. And that regulation could not be made under the new rules because they are not recruited under the new rules. They have to face the direct recruitment. Only relaxation can be given to their higher age. Only age can be relaxed to 10 years. Otherwise, they have to face the direct recruitment test. But they have not faced.
That,
how do you discriminate between those 5 and him?
That you also can see my counter affidavit, paragraph 7. Well, why such things were happened? That may be running page 57, internal page 5, paragraph 7. It is submitted that the opposite party number 7 was recruited as a pharmacist on contractual basis during the year 2006. She did not hold any ex-cadre post. At that time, the government of Odisha was observing austerity measures and there was restriction on recruitment of base level post. Since there was shortage of pharmacists, the opposite party number 1 decided to recruit 5 pharmacists on contractual basis. The rules 1997 envisaged recruitment on regular basis only and not on contractual basis. On the request of the opposite party number 1, the Steel and Mine Department, Government of Odisha by letter 1/2006 communicated its approval for filling up of 5 vacant posts of pharmacists in the opposite party number 1 on contractual basis with consolidated remuneration of rupees so and so. The opposite party number 7 was declared successful by the selection committee of OMC. Accordingly, the opposite party number 7 was appointed as a pharmacist on contractual basis on 6/3/2006. Needless to state here that the opposite party number 7 was appointed pursuant to a regular selection process. Then last subparagraph, as approved by the Board of Directors of OMC Limited in its 398th meeting held on 26/3/2013, service of 5 numbers of pharmacists, including the opposite party number 7, appointed on contractual basis were regularized. Since the opposite party number 7 have faced the regular process of selection, no further selection process was needed. The initial appointment of the opposite party number 7 was made on government's approval and regulation of service was made after the Board of Directors of OMC Limited accorded necessary approval. No illegality was involved in the process. The opposite party number 1 has accepted the appointment of the opposite party number 7 as pharmacist on regular basis with effect from 1/5/2013 under the new rules 2020. And so far as the benefits which the petitioner has received in lieu of promotion, that we have stated.
His selection also must have been on a regular basis only.
Petitioners, yes,
Ah.
yes.
So what is the distinction where I'm unable to follow? You say when it comes to opposite party number 7, the selection was on a regular basis, although appointed contractually and therefore regularized under the new rules.
Yes.
What is the difficulty in regularizing him under the new rules?
No, his case.
I am regularly appointed in 92, facing the recruitment.
That's what
But he was, she
Sir,
was
we are
not.
trying to tell something in your favor to him. If you want to let us do it, we'll do it. If you do not want to do us, we'll not do it. Let him answer.
The day when the case of the opposite party number 7 was taken into consideration for regularization, on that day, 2012 rules came into force.
No, why not the petitioner? That's the only question, sir. If you could
No,
do it
by
for all the others, why not him?
No, by that time, the petitioner was already regularly appointed since 1992.
Not regularly, contractually appointed.
No. Petitioner was regularly appointed in 1992. Only the opposite party number, since there was austerity measure and there was a restriction of the government for regular appointment in order.
What is the problem in giving him promotion? That's the only question.
Well, in lieu of promotion, he has given all the financial benefits.
It's not the same thing as getting promoted, sir. There must be some valid reason for not giving promotion.
That we have explained. You will also kindly see.
That is all technical explanation. We don't know in merits what is the
Paragraph 5, you will also kindly see.
All right.
It's running page 54.
Yes.
The petitioner was recruited as a pharmacist under the prevailing provisions of OMC Recruitment and Promotion Rules 1976. The petitioner joined the regular post of pharmacist on 16/10/1992. The rules 1976 were replaced by the Odisha Mining Corporation Recruitment and Promotion Rules for non-executives 1997. But the service conditions of the petitioner, along with other pharmacists, senior pharmacists appointed under the rules 1976 were kept unchanged. Subsequently, the Odisha OMC Limited rules for non-executives 2012 came into force. The service conditions of the pharmacist, senior pharmacists, and other employees recruited under the provisions of rules 1976 and rules 1997 were also kept unchanged. It is submitted that though both the rules 1997 and rules 2012 are simultaneously in force at present, but recruitment is being made only under the provisions of new rules 2012. It is relevant to mention that though the petitioner has alleged about the discrimination meted out to him by the application of new rules 2012, but the petitioner has not spelled how the petitioner is affected by the new rules 2012 or discrimination has been meted out.
Why not, sir? So his base, very simple point is those who have been appointed as junior pharmacists after he was appointed, they've all got promotions as senior pharmacists. He's staying behind. That is the discrimination.
No, once the 2012 rules came into force from 1st of October 2012, well, all the pharmacists were given appointment under the 2012 rules.
So you, by the 12 rules, you devised a different criteria.
Yes.
Under the 12 rules, even if you are appointed earlier than the 12 rules, you are giving promotion under the 12 rules on completion of 4 years as junior pharmacist. Correct?
No.
Yes. Under the 2012 rules,
Yes.
if you complete 4 years as junior pharmacist,
Yes.
you get promoted as senior pharmacist.
Yes.
Whereas under his rule, you don't have no such provision.
No, provision for promotion is there, but that is on
Not on completion of 4 years.
No, on vacancy base.
So isn't that a discrimination? Then everybody steals a march over him. The poor man has been working since 92. Others who come later, to them you apply the new rule and you promote them quickly.
In order to,
it's an obvious discrimination.
In order to compensate that, well, he has been given all those financial.
It's not the same thing, sir. It's not the same.
That I have explained in the next page, all those financial benefits which have been given to the petitioner.
What's wrong in giving him the promotion itself then?
No, this is not the single employee. There are a large number of employees.
Everybody has not come forth.
No, this will be applicable to all employees.
No, that is up to you to decide what you want to do. If somebody comes forth to point out discrimination, you have to answer it. The answer can't be so many others will have to give the same benefit. That can't be the answer.
And in similar situation, the Honorable Court has negated the claims also.
Who has, who,
judgments.
which judgment? That's why he's challenging the virus of the rule itself.
Here, my lord, the post of deputy secretary, to the post of deputy secretary, there are two sources of recruitment. One from the Rajasthan Administrative Service, and the other mode of recruitment is from the source of Rajasthan Secretarial Service. And the government took a decision to grant special pay to the Rajasthan Secretarial Service, to Rajasthan Administrative Service, but the same was not given to the Rajasthan Secretarial Services concerned. Now, that was under challenge. You also can see paragraph 3. It was on the basis of these rules that the appellant filed a petition under Article 226 of the Constitution before the High Court of Rajasthan, claiming that the words without special pay in the Rajasthan Civil Services rationalization of pay scale rules and schedules 1956 may be declared as invalid and violative of Articles 14 and 16 of the Constitution. The High Court dismissed the petition, and consequently the appellant has now come up to this court by special leave. 4 is not relevant. Paragraph 5. Aspect, and the one on which reliance was mainly placed by Lord Counsel for the appellant in this appeal, is that the rules on the face of them show that in the case of members of the RSS appointed as deputy secretary, no special pay is admissible, while special pay is admissible to members of the Rajasthan Administrative Service when holding similar posts. It is on the
Services
basis.
are not identical. So there, the para 6,
Yes.
the two services are not identical, sir.
Here also same.
No, they're identical.
Here also same.
Here are junior pharmacists same. Only the year is different.
No, recruitment method of recruitment is different. Qualification is different.
Correct.
There are two reasons why this grievance put forward on behalf of the appellant has to be rejected. The first is that the appellant comes to the
Correct.
post of a deputy secretary from Rajasthan Secretarial Service, which is a service distinct and separate from the Rajasthan Administrative Service. The methods of recruitment, qualifications, etc. of the two services are not identical. In their ordinary timescale, the two services do not carry the same grades. Even the post for which recruitment.
But here I think they carry the same grade. Junior pharmacist under the new rule.
Yes.
And junior pharmacist under the old rule must be carrying.
No.
Yes. Where do you say it's a different grade? Pay scale? In fact, here the question is not on pay scale at all. You've picked up a pay scale judgment. Here we are only on the chances of promotion. In fact, you say the service conditions of pharmacists, senior pharmacists, and other employees recruited under the provisions of 76 and 97 were kept unchanged.
No, that is 1976 and 1990. Next page, you can see next page, page 55 top. Under the rules 1997, the post of pharmacist and its promotional post of senior pharmacist constitute a single cadre, whereas there are several subcadres like hospital attendant, dresser, nurse pharmacist, radiographer, and laboratory technician come in the new rules 2012. Each subcadre has 2 or 3 posts under it. Each base post has promotional hierarchy and prescribed norms for promotion. A junior pharmacist under the 2012 rules, after completion of 4 years in the post, becomes eligible for promotion to the next higher post of senior pharmacist. Since promotion of a pharmacist to the next higher post of senior pharmacist under the rules 1997.
That's all. It's only vacancy based.
Yes.
Here. It's on number of years of completion. There's no other difference, sir.
Yes.
You're not for a minute saying that he's not qualified.
You see, there was no vacancy under the 1997 rules.
Sir, is there a separate vacancies under each set of rules? The post is the same. How can there be separate set of vacancies under each rules?
No,
For
under
the same post.
Under the new rules, it has been created. Several posts have been created. That was
But there are always a post of senior pharmacist, whether under the old rules or the new rules.
No.
You're not creating the post of senior pharmacist.
No, there are several posts have been created.
No, other posts, sir.
Yes.
But as far as senior pharmacist post is concerned, it existed under the 97 rules. It is existing in the 2012 rules. You're not creating any new posts.
No, new posts are created. Suppose the number of posts are increased.
Vacancies may be increased, sir.
Yes.
Post remains the same.
Yes,
It's not a new post.
yes. Senior pharmacy post is there.
He is always there. So you're not creating some new post. There's no satisfactory explanation. Only difference is that was vacancy bound. Here it's time bound. Why should he lose out? Because you changed the rule later and you did not make those rules applicable to him. Normally, when you repeal and savings normally means you replace the old rule with a new rule.
And since that is a dying cadre, so it has been allowed.
You can't then
That has been allowed.
finish them off. We'll reserve it.
And there is another judgment also.
Tell us.
There also one increment was granted to the persons who are holding the.
That's right. Monetary benefit is one thing, sir.
Yes.
Promotion is another. See, monetary benefits, because of the nature of duties, you can always say some extra benefit. Here, the nature of duties is not different. The issue here is something else. The issue here is not on pay scales or nature of work performed. It's not on that. All right. Orders reserved.
Also, may I submit the DS Nakara case that is there?
That is on pension, sir. Please. That's something else altogether. Yes.
Weekly list item number 10.
What is a connected writ petition? Same thing. There are two writ petitions.
Yes. Second petition, I have challenged all the 5 who are promoted in 2000.
Why challenge a promotion? You'll also get promotion. Why disturb their promotions?
Yes. Lordship may see, there I have made party to all 5 persons who are promoted in 2017.
Who is appearing for all of them? Nobody seems to be appearing on their behalf. Anyway, all right.
In the connected case, it shows that notice is not sufficient.
No.
Not on all of them, only on some. Counter has been filed by 6 and 7 also. 6 and 7 must be the private parties, correct?
Yes. Through registered post, notice has been sent. All the 5 are made parties. Lordship may see, second writ petition from opposite part number 8 to 12.
6 and 7 is OMC. The connected case,
Lordship may see, from 8 to 12, those who are the private opposite parties, they are made notice are sent through registered post. That there the promotion order was.
No, but what about notice on 8 to 12? No, 8, 9, 10, 11, all after valid service. They've all been served. Only OP number 12, AD was not back, but everybody else has been served. They've all been served. All right, orders reserved in both petitions.
Weekly list item number 10.
That appears dismissed.
Weekly list item 11.
That appears dismissed.
Lordship, in this matter, Lordship, kindly see order to 7/3/2018. If we're coming to the facts of the case, Lordship, there is a judicial order on 7/3/2018.
What is the fate of the departmental inquiry procedure?
Lordship, that because that is the order itself, Lordship.
Instructions with regard to
It's adjourned all the time, sir. Opportunity was already granted on 24th April. Adjournment is already granted. So 24th April, look at the
Yes,
24th April order.
Yes, Lordship, I've seen.
Tell us what the matter is about. You need not wait for that. Tell us what it is about.
Lordship. If Lordship, here I'm challenging the order of the collector because Lordship a person, the Lordship kindly come to section 122 of the OGP Act, Lordship.
No, you were placed under suspension contemplating disciplinary proceedings.
Lordship, because a person who is working under the Gram Panchayat, my only submission, collector has no power. And this issue has already been decided by this Honorable Court. And that's Lordship given a judgment in Fakir Mohan's case, Lordship. That has been, but Honorable Single Judge, while considering the judgment, they hold that Lordship because in absence of rules, though that is, they have admitted that facts remains, Lordship, the collector has no jurisdiction, but in judgment itself, it has been reflected because in absence of rules, collector has power. So my humble son before Lordship, absolutely collector has power. I also don't mind Lordship, collector has power. But when he is under collector, when a person is working under the Gram Panchayat, then collector has no power, Lordship. That's why Lordship kindly see the section 122. It is very clear. And it has been, Lordship, because the old Act 122 section 122 of the OGP Act, Lordship, but here is the executive officer of Gram Session. In fact, for every Gram Session, there shall be a Panchayat executive officer to be appointed by the collector who shall maintain the records of the proceedings of the meetings of the Gram Panchayats. Then B, Lordship.
1 minute. What are you reading?
Lordship. 3, Lordship. 122 of the OGP I'm reading, Lordship. In fact, Lordship, I am confined on 3. Subject to the provision of subsection 1, the Panchayat executive officer shall function under the control and supervision of the Gram Panchayat. Right. So, Lord, a person while working under the Gram Panchayat, my only submission, Lordship, collector has no power. Had it been a case, he will be brought back to his original position. Collector has absolute power, I don't mind, Lordship. But a person while working under the Gram Panchayat, the very earlier the section was, Lordship, he is under the control and supervision of the collector, director, and all are there, Lordship. In Fakir Mohan's case, the said provision struck down and declared as ultra-virus to the Constitution in view of the Article 243G, Lordship. That's why the government come up with this amendment. But the pupillage of the order, Lordship, can see 109, 10 and Lordship, 110, Lordship, can see 9, 10 and 15. Honorable Single Judge has relied upon 109, 10 and 15, Lordship. 109, Lordship, that is control over the Gram Panchayat. Subject to the provisions of this Act, the rules made thereunder, and any special general orders issued by the state government from time to time, the director, collector, the district panchayat officer appointed by the state government, or such other officer person specially authorized in that behalf by the state government shall exercise general powers in inspection, supervision, and control over the exercise of powers, discharge of duty, and performance of functions of Gram Panchayat under the provisions of this Act. Then let's say 110. Inspection, powers of inspection, supervision, and control in respect of the particular matters. Without prejudice to the generality of the powers conferred under section 109, the director, collector, district panchayat officer appointed by the state government of such other officer or person authorized under the said section or authorized by the director, collector, or district panchayat officer in pursuance of any special order.
You are saying this power does not extend to individual employees.
Lordship, but
individual employees are governed only by the executive officer.
What my humble submission, Lordship, this enactment came in 2001, but your Lordship has struck down in 2009. 2008, and that's why state government come up with amendment in 2009. So these two provisions is not applicable to the present case. So the original 122, which was enacted by the state government, giving such power to the collector, and that was struck down by this Honorable Court. And accordingly, they come with amendment with coming 122.3. Now the provision says, Lordship, the employees of the Gram Panchayat under the executive officer is coming under the control and supervision of the Gram Panchayat. So a person while working under the Gram Panchayat, he cannot be, let's say, removed or take any disciplinary action can be taken against him while he is working under the Gram Panchayat. And let's say, Lordship kindly see the peculiar to this order while considering the application.
The only thing is, even if he strike down this order placing you into suspension, if the disciplinary inquiry is already over and you've already been punished, then it will not apply.
Lordship, that's why Lordship.
Anyway, there's no point in going on adjourning it because they will again not get any instruction. Already 2 adjournments were granted.
Lordship, that is their Lordship.
And you should be aware. Your own client.
No, in fact, Lordship, I have no instruction because today morning I'm coming.
Both sides you have no instruction.
That's morning I'm coming, Lordship. I was out of station, Lordship. That's why Lordship, I don't have any information. If Lordship grant adjournment, then I will also.
Neither side is able to inform the court of the current status of the disciplinary proceedings. Both counsel want time for that purpose. List on. That side, is it? This side. All right.
Let's
13 December. Give me those lists.
All right. Item number 12. Item 12.
Manner case dismissed.
Item number 13.
May I please? My lord, there are 2 connected writ appeal, my lord, arising out of the same order. I am in the first appeal, my lord. That is writ appeal number 75 of 2018, my lord. Here the present appellant challenging the order dated 11/1/2018 passed in WPC number 9622 of 2016 that the order of the Honorable Single Judge is erroneous and not considering all the material facts, my lord. The case of the present appellant is that the respondent number 5 has coming to the writ petition challenging the order of the appellate order by the ADM, my lord, where he has taken that the selection is illegal, my lord. And being agreed by the respondent number 5 challenging this writ appeal, and in the writ appeal, the Honorable Single Judge hold that since there is delay, so therefore he is not after selection.
Correct,
but I want to draw the kind attention of this Honorable Court, my lord. I have filed my counter, my lord. Where counter in this, after the notification is on 23/12/2019 and selection is on 24/6/2010. Selection is completed and they have given appointment to the respondent number 5, my lord. After that, there was an appeal in my counter at that, my lord. I have specifically stated in my counter, which I filed in the writ, my lord, on 23/6/2016, where I have stated that I want to draw the, after selection, my lord, the one Srimati Kanaklata Chand was filed an appeal number 107 of 2010. And 2013, due to non-process, that has been stopped. And thereafter, the present appellant filed this case. So, very beginning of the selection, there was dispute that the respondent number 5 has applied not for the as per the guideline, because there are 2 podas, my lord. One is Nandika poda, Nandika Patra poda, and another is Bhanjo poda, my lord. The present respondent number 5 applied for the post under the Bhanjo Sai, my lord. not for the Patrasai Nandika side. But he has selected to that. Therefore, that is the irregularity which has been.
When did you challenge this question, sir? The impugned order says you woke up after 5 years.
My lord,
to file an appeal.
My lord, my humble submission, if the Honorable Court has gone to my counter that very beginning.
That's supposed to counter. I don't understand. This was your writ petition which has been dismissed, correct?
No, that is not my writ petition. I am the opposite party there, my lord. Writ petition is filed by the respondent number 5. Being agreed by the appealer.
No. In the appeal, you were the appellant.
Yes, my lord. And the appellate order is very clear to that, my lord. It is that was annexure 1 in the writ petition, my lord. I am placing as page 13 to 15. The relevant person at 15, my lord. It is revealed that respondent number 2 has filed application for the post of Anganwadi worker for serial number 29, ward number 13 for Bhanja side, whereas the appellant had filed application for serial number 28, ward number 13 for the Patra side, Nandika. But the CDPO Jaleshwara has taken the application of the respondent number 2 for Patra side, Nandika, Anganwadi center, not considering the application of appellant since she belongs to the. But to that effect, the CDPO Jaleshwara has not submitted service area list of the beneficiaries residing within the service area. The above aspect has not been examined by the selection committee while selecting Anganwadi worker for Patrasai Nandika Anganwadi Center. In view of the above, it is held that the selection of Anganwadi worker has been made without proper verification of the application form filed by the applicants to the post of Anganwadi worker. Hence, the appeal is allowed.
No. So when was the appeal filed? Appeal was filed in 2015.
2015, my lord.
For a selection that took place in 2009.
2010, my lord.
How did you explain 5 years delay?
My lord, my point is that after selection in the year 2010, there was an appeal. Amongst the applicant, another applicant, which I have stated in my that appeal number is 107 of 2010.
No.
That means
you were not the appellant there, sir.
My lord,
you were not the appellant. Somebody else filed an appeal.
But my humble submission, when the irregularity has been drawn to the attention of the authorities.
Please. You still have to explain what were you doing? Why were you sleeping over your rights? You see, the appellant challenged the appointment of respondent number 5 as Anganwadi worker. In respect of the Patra Sahi Nandika Anganwadi Center under the Jaleshwar ICDS project, by way of appeal case number 2 of 2015. More than 5 years after the selection took place in 2010. So without examining the aspect of delay in filing the said Anganwadi appeal case number 2 of 2015, the additional district magistrate (ADM) Malaysia allowed the appeal. And directed the selection committee to look into the matter. Stop. The said order dated 12th January 2016 was challenged by the opposite party, the respondent number 5, in writ petition civil 9622 of 2016, which came to be allowed by the learned single judge by the impugned order dated 11 January 2018. Full stop. The learned single judge has observed that there is no reasonable explanation No, that the appeal itself was highly belated. And ought not to have been entertained by the learned ADM. And on that short ground has allowed the writ petition, setting aside the order of the ADM paragraph, having heard learned counsel for the appellant. The court is not persuaded to come to a conclusion different from that arrived by the learned single judge. Full stop. Indeed, there is no valid explanation for why the appellant waited for 5 years to challenge the selection of respondent number 5. Respondent number 2, is it, or 5? Respondent number 5. Full stop. Learned counsel with the appellant sought to suggest that some other person had filed an appeal challenging the selection of respondent number 5, and this was filed soon after the selection took place. Full stop. The said appeal was not pursued, is it?
Well, in the 2013, that has been
Dismissed
for non-prosecution.
The said appeal was dismissed for non-prosecution in 2013. Full stop. He accordingly submits that it is not as if the selection of respondent number 5 was not challenged immediately after it took place. Paragraph. The above explanation still does not explain why the present appellant kept quiet for more than 5 years to challenge the selection of respondent number 5. Full stop. Consequently, the court is unable to find any error having been committed by the learned single judge in passing the impugned order. The writ appeal is accordingly dismissed. What is the next one? Writ appeal 82, same thing.
The same another person. That my lord.
For the reason stated today, while dismissing writ appeal 75 2018, the present writ appeal is also dismissed.
My lord, it is admitted that there is no time limit for the that has been taken into
in fact, that's why this learned single judge says 3 years is a reasonable time, 5 years is not.
Quickly list item 14. Item number 14.
None appears dismissed.
Item number 15.
May I please, minutes? The impugned order is at page 101. The order starts from 103. I'm placing the impugned order in that. Challenging the common order passed by the Learned Commission of Consultation Bhubaneswar in division case number 583 of 1996 and 1 of 1997 on 3597. The petitioners have filed this writ petition as in both the revision.
How is this writ appeal maintainable, sir?
Pardon, Miller?
How is this writ appeal maintainable? The single judge's order
Miller
is passed in a writ petition challenging an order in a revision case. How is a writ appeal maintainable against that?
The consolidation revision case.
Correct. So a challenge order to a challenge in a revision case is done in a writ petition, correct?
Miller, what happened, Miller?
So I don't know if you are following it. The jurisdiction
I followed my lords. Your lordships on the maintainability of the writ appeal, Miller.
Because it's a 227
Miller
jurisdiction. And anyway, the matter has only been remanded to the commissioner for a fresh adjudication.
That's true, Miller, because Miller, the same issue, three revisions were there, 2 writ petitions are here. Both the writ petitions, my lord, the first revision was disallowed, that was challenged, and that writ petition was also the subject matter of issue before this honorable court. But those matters are not dealt with, my lord. This is my case, my lord. My lord, I have annexed all the documents, my lord.
There has been no stay granted of the single judge's order. In this court, in the division bench, there has been no stay of the single judge's order.
That is not the case. My lord, this is a.
Are you following or you're not following?
I'm not following, my lord.
The single judge has passed an order.
My lord.
You are in appeal against that order.
My lord.
That order has not been stayed by this court.
Which order, my lord?
Of the single judge, sir. The order of the single judge against which you have filed this appeal,
my lord,
has not been stayed by this division bench.
My lord, is not stayed.
How? The single judge has only ordered a remand.
Yes.
That remand must have already taken place.
No, my lord. The remand is fixed to 7/12/22.
All right, let it take place, sir. Let it take place. You must be going there and getting it adjourned saying writ appeal is pending.
My lord, what happened while the single judge was dealing with the matter? My lord, the principle of res judicata was raised. That was not taken note of by the honorable single judge. This is my case, my lord. My lord, may kindly see the order, my lord, I have annexed. Lordships may see, my lord, let me to place, my lord. Two revisions are there. One 583/96 and another, my lord, one of 97, my lord. My lord, in the present appellant was never a party to the revision, that is 583/96.
Which is why you've been sent back, sir, for you to be heard.
May I finish, my lord? My lord, thereafter, your lordships may kindly come to my lord, the order is, your lordships may kindly come to page 17. Page 17, my lord, after dismissal of the writ petition, this present writ petition against which the appeal was preferred, that was earlier dismissed by this honorable court. That order of dismissal, after dismissal, again some villagers again filed the revision before the commissioner. The commissioner dismissed the revision, my lord. Thereafter, writ was preferred. My lords may kindly come to page 23. Page 23, my lord, the writ petition was dismissed. Same issue, same property, same issue. My lord, after dismissal, my lord, another revision was preferred. That is revision number 462/2008. But in that case, the Lord Commissioner directed for remanded the case to the SCO, my lord. But that was challenged also in the WPC number 20262, that is page 29, my lord. In that writ petition, this honorable court also rejected, allowed the writ petition and directed that this was earlier dealt by this honorable court. There, after a gap of 9 years, some odd months below, this CMAPL was preferred.
Yes.
My lord, this writ petition was earlier dismissed of 8/1/2004, and the CMAPL was filed after 9 years some odd months. That, my lord, at Annexure 5, page 34, and without issuing notice and condoning the delay, the writ petition was restored. My lord, I have annexed, my lord, that document, that order, my lord. My lord, may kindly see the order at page 41, my lord, the Annexure 6. The order I am placing, my lord. The application has been filed by the petitioners for restoration of OJC 16459 of 97 to file, which was dismissed for default on 8/1/2004. This order was passed on 20/12/2013, page 43, my lord. So many litigation. Who are they? What is their locus standi? They are the villagers, and they have also they have forged the signature of some petitioners. By forging the signatures, the writ petition was filed. That was brought to the notice of this honorable court. And thereafter, when this matter was informed to this honorable court, 3 of the petitioners proceeded with the matter. I will file a detailed date chart, my lord. The dates and events. So many cases are there. So many revisions are there. They have no locus. And moreover, I am not a party to that revision. And two revisions are there. Two read persons were supposed to be filed. That was also brought to the notice of the Honorable Single Judge. The Single Judge never dealt with that matter. This is the background of the case, Miller. 9 years delay, more than 9 years delay was condoned without issuing notice. And after restoration, this remand order was passed under Annexure 8. After 20 years, a settled position is going to be unsettled. Absolutely, the villagers have no right. This is personal property.
Sir, are you permitted to ask you a question or no permission from you for us to ask you questions?
No. Permission always
very
to
ask me questions. Very deeply obliged to you, sir. Very deeply obliged. So can you tell us what is wrong with the order of the single judge?
Background matters I have told, the read person was dismissed.
If I were in your position arguing a writ appeal, I would draw the attention of the bench to the order under appeal.
Yes.
And I would tell the division bench why the order under appeal is wrong. That is how I would argue the writ appeal. But each one has his own way of arguing. Till now, you have not read the order of the single judge, but you made all the arguments.
I have read it, my lord.
I see. Then it's okay. Then you have anything more to say, sir?
My lord.
No, 1 minute. You have anything more to say? If you already read the order of the single judge before us?
My lord, I have not read the order before us, but I have read the order.
Very good, sir. Very good. Then you don't need to read it before us.
It is need to read.
Okay. Sometimes we wonder whether we should be asking questions at all, because lawyers get so agitated if the bench asks questions. When we were lawyers, we would welcome questions from the bench, because lawyer needs to know what is passing on in the judge's mind, correct?
That's right.
Suppose you get very agitated, sir, don't ask me questions, allow me to argue, don't ask me questions. The judge will just allow you to argue, not ask you questions at all. Then you will have no idea what is passing on in the judge's mind.
My lords may ask me questions.
No, you're very kind, sir. You're very considerate. But when we ask you questions, you don't want to answer the question. That's the problem.
No, that cannot be.
Yes.
Whenever your lords will ask me questions, I am bound to answer.
Okay. Anything more you have to say, sir?
But I pray for a small adjournment. I will prepare a date.
We are not granting adjournments. We have heard you so patiently. We don't have the heart to give you adjournment. You've argued so well.
My lord,
yes.
The grounds I have taken in the writ appeal,
yes.
my lords may kindly permit me to place, my lord.
All right.
The ground number 1.
All right.
My lord, the honorable single judge failed to appreciate the self-same suit plot was subject matter in issue before this honorable WPC number 15300 of 2005, decided on 7/2/2005, and WPC number 20262 of 2009, decided on 11/2011. Except the names of the repenting villagers, in all the 3 read persons, the subject matter is directly and substantial in same. Therefore, the matter is hid by principle of res judicata. That was not dealt with by the honorable single judge. My lord, the ground number 2, because the honorable single judge failed to appreciate that the CMAPL to restore OJC 1645997 was filed after 9 months, 2 months, 12 days from the date of dismissal by forging the signature of the petitioners number 1, 5, and 6, and by stating falsehood which are available on record. And at the ground number 3, because the honorable single judge failed to appreciate that no notice on CMAPL nor the miscase for condonation of delay was issued to the opposite parties. The CMAPL The CMAPL was allowed at the first instance of listing on 2012-2013. No orders is passed for condonation of delay. My lord, because the honorable single judge failed to decide before entering into the merits of the case as to whether the writ petition can be entertained at the instance of the villagers number 3, 4, and 7 as representatives of village Basandio, where the petitioners number 1, 5, and 6 in their letter to the High Court have mentioned that there is no encroachment of public road and approached for withdrawal of the writ petition. The petitioners number 3, 4, and 7 have no locus standi to proceed in the writ petition. Because the appellant was never a party to revision case number 583 of 96. The prayer in the said revision case is to correct wrong recording of 01.01 decimal in the names of opposite parties number 2 and 2 to 7. The Law and Consultation, the Commissioner Consultation has rightly given his finding that LR plot number 1418/2528 acre 01 decimal has been recorded in the name of opposite party number 2 to 7 without any basis. The finding of the honorable singular that no finding have given by the Learned Commissioner Consultation Bhubaneswar when villagers are putting forth a submission that no land is available on record in the name of Babaj Kuntia on his vendis without calling for the LCR is not correct and cannot hold good. To this regard, my lord, I have also enclosed the report of the Amin under Annexure 9, my lord. When my next ground, my lord, because the Law and Commissioner Consultation Bhubaneswar has rightly dismissed revision case number 583 of 96 and a remanded revision case number 1/97 for correction of map and records after field visit by order dated 3/5/97. Acting the Law and CO, Gop Kakatpur finally adjudicated the remand revision case number 1/97 on 9/1/98, which is annexed to the writ petition as Annexure 10. The so-called representatives of village Basandio have never preferred appeal before the appeal against the said order. The Honorable Single Judge has not noticed this aspect while deciding writ petition on 17/1/2018. My lord, because after order passed by the Law and Commissioner Consultation Bhubaneswar in revision case number 1 of 97 on 3/5/97, the appellant has sold LR plot number 1418 of stroke 2518 acre 01 decimal to the respondent 7 to 12 and pursuant to the order in remand case number 1/97. The suit plot has already been recorded in their names in consultation Khata number 75. Plot number so and so, and ROR was published on 22/4/98, which is annexed as Annexure 10. My lord, after elapse of 20 years, now the remand is made. This is my grievance, my lord. This is all my submission.
All right. We'll pass the detailed order. The writ appeal is dismissed. We'll pass the detailed orders. All right.
Quick list item 16.
None appeals dismissed.
16 men, I will for the respondent.
All right.
Quick list item 17.
My pleasure, Lord. In item 17, there is 4.5 months delay in filing the appeal. Well, I may be permitted to take notice to the private opposite parties.
You have to explain the delays first.
Yes. But the present respondent was non-represented when the writ petition was taken up for hearing. But I have explained the delay. The development authority was represented by the council, but at the time of hearing, the authority was non-represented. Therefore, the matter was not within the knowledge of the development authority, my lord.
You have to follow up, sir.
But however, my lord, when the writ petitioner submitted a copy of the order of this honorable court, the authority, my lord, immediately thereafter inquired into the matter and filed the appeal, my lord.
No. Para 3, you come to para 3, sir?
Yes, my lord. The fact of passing of the order dated 18/10/2017 came to the knowledge of the present petitioner only when the present opposite party submitted a copy of the order before the authority on 2/11/2017.
That's not very far, sir. Between 1810 and 211, it's not even 2 weeks.
On receipt of the order, the present petitioners inquired the matter from the Learned Counsel immediately over telephone and came to know the ignorance of the Learned Counsel with regard to the order. However, the Learned Counsel took some time to get the updates and on...
What is updates? You already have the order of the single judge before you. Where's the question of updates?
On 18/1/18...
As far as your filing the appeal is concerned, sir, you should have filed it immediately.
Immediately the authority have taken steps and inquired matter from the Learned Counsel.
No question of inquiry. So if you're aggrieved by an order, the order is dated 1810.
Only it was confirmed by the Learned Counsel, without his confirmation. And thereafter, we applied for the certified copy, and getting the certified copy, immediately filed the appeal. In the
what is the relief granted? Let's see.
Here, the matter relates to allotment of plot.
Yes.
You lots may kindly see the prior to the order impugned in the writ appeal, may place the Annex 4 to the writ application, which is the brochure for allotment of the plots.
So this is the order of the single judge is 1810/2017.
1810.
There is no stay granted by this court. In fact, this writ appeal has not come of hearing even once.
It was listed once on 5/3/2020, but it could not reach.
All right. So there is no stay granted.
No stay granted.
You have implemented the order or you have not implemented?
No, because we have appraised this honorable court.
So self-granted stay. You have granted yourself a stay.
We have intimated the opposite party that we have approached this.
So there's no need to implement. There seems to be an amendment, Orissa amendment to the constitution. The minute you file an appeal, don't implement any order.
Let me kindly see the impugned order, after 20 years, the writ application was disposed of, but considering the concession given by the authority at the relevant point of time, but the writ petitioners did not deposit the first installment even and did not return the acceptance letter with regard to the allotment. Well, they have not deposited a single pie except the EMD. After the EMD was deposited and they were selected, well, they were intimated that you deposit the first installment and return the acceptance letter. They did not return the acceptance. They did not accept that, and also did not deposit the first
Basically, the single judge has given them one more chance. Do you have those plots still? You have not cancelled the allotments.
But no, we have not cancelled.
So you will get the current market value, sir.
Allotment. Let me observe that. Our only submission, now the properties are put to auction. It is for public purpose that put to public auction.
You already put it to auction?
No. Without the clarification from this honorable court, we cannot do that. The honorable single judge has only directed to calculate the interests. So our submission.
No. When it says submit a calculation sheet of the amount with interest.
With interest only.
No. It means the amount as originally charged, is it? Not the current market value.
No, not the current market value.
Where are these plots in Bhubaneswar?
No, it is under Barampur development.
Achha. But it's the main city.
Now in the prime location.
I see. Right. You say notice on stay as well. Returnable. January 16th.
Item number 18.
Obliged. May I please, Lordship? The Lord single judge decision order is under challenge. Only we have considered many things in before, but question is that he has expounded the law. That is the difficulty for the bank. That 47, it has quoted 47.
right to appeal. But while passing the order, yes, we have enhanced the punishment. The appeal authority has enhanced the punishment without giving notice. That we have fairly considered before the learned court that yes, we could have given a notice to the concerned chartered employee. But after that observation, the learned single judge has held no, right of appeal only includes three. Either you can you can only reduce or agree with the finding of the inquiry officer or remand the matter. But right to enhance the punishment with a show cause, that is conspicuously absent. This is the only point. We are not having any quarrel.
Served or not?
But my lord, here one development. At the time of hearing of the matter, the petitioner concerned here with the sole opposite party did not inform the court that he has been dismissed from service. And we could not inform the court because of the difficulties, because he was earlier on the Kottagram Bank bearing the PF number. But when the banks were amalgamated in 2013, they carried the roll number. So we could not match, but at least the petitioner could have informed that by the time the hearing was taken up, he has been dismissed 2 years before by another fraud of some 14 lakhs and he dismissed from service. Here's 1.6 crores involvement. We only the sole point of law involvement, the right to.
No, what has happened? There's no stay granted.
No stay is granted.
Then?
And but he has gone with the order of the learned single judge, but by that time he had been dismissed.
So why do you want to pursue it then?
But only one point of law, my lord.
Has he filed a contempt?
My lord, right of appeal.
Has he filed a contempt petition? And then why are you worried? What are you unnecessarily? What are you pursuing the matter for?
That remains unsolved. Right to appeal authority doesn't have the power to enhance. That is the only.
Sir, he has not filed any contempt. You have not implemented the impugned order. Why are we bothered about it?
But this will be treated as a law for bank. Right to appeal enhancement of punishment.
All right, you say leaving the question of law, considering that
yes,
there has been no stay of the impugned order of the learned single judge, and considering the fact that the respondent has already attained the age of superannuation, leaving the question, the court is not inclined to interfere. The questions of law arising from the impugned judgment of the learned single judge left open for decision in some other appropriate case. The appeal is dismissed to the above observations. Bill is controlled.
Item number 19. Item 19.
None appears dismissed.
Item number 20.
None appears.
Item number 20 on behalf of Ajodhya Ranjan Das, my lord, is now government pleader, my lord. He informed appellant to engage some.
All right. Counsel for the appellant states that despite informing the appellant that he should engage some other lawyer, no lawyer has been engaged. On behalf of the appellant, dismiss for non-prosecution.
No, my lord, he for 1 week time.
Why should be? You've already informed him he is not engaged in it.
Last day before yesterday, he was informed, my lord.
You should have informed much earlier, sir.
He requested us to take a 1 week time to. And
you are appealing.
I am
Respondent.
For 1 week time, my lord.
The court is informed that Mr. A.R. Dash is now a government counsel and therefore has asked the appellant to make alternative arrangements. List on.
Hmm?
25th January.
Weekly list item 20.
Yeah, but till the lawyer appears, he will not take steps.
Item number 21.
Very please, please. This case, my lord, the short issue involved in this case, there was an advertisement by the Veera Surendra Sai Institute of Medical Science and Research, the Bhimsar Bulla, which is an autonomous body, to fill up the post of assistant professor in different disciplines. And as per the Odisha Medical Education Service Rule 2013, that is their act also. Rule provides that the qualification, minimum qualification is PG in concerned discipline with SR, senior residency, 3 years experience. But in the advertisement, what they have done, they have inserted a word which is not there in the rule, that 3 years SR in the concerned discipline. That is why we are debating.
We just dealt with a similar matter, sir.
I don't know.
This had to do with which is this? Hariyar, Acharya Hariyar. So
no, that is Acharya Hariyar. I have gone through that is quite different. There the rule provides, advertisement provides, and those persons challenge that advertisement after participating in the process. That I have gone through. That Dr. Some Khadanga or something like that. I could not.
Whatever. So
but
there
here
the argument there also was that advertisement provides for some condition which is not there in the rules.
No, that was there. I was also some counsel in the single bench. The writ appeal, somebody else was arguing here. I know the facts of that case. If my lord call for the file, then also my lord can verify the facts, whether I am correct or not. Here, I am challenging I was challenging before the single judge, this is the advertisement itself, the stipulation in clause 8, wherein they have inserted this word. That is why my lord, while issuing notice in the matter, notice was issued, and my senior friend, Mr. Shishir Kumar Purohit, was appearing. Today, I don't know whether he's there or not. But the problem, sir, they have their separate set of counsel. And
no, so you did not participate in the selection here?
No, I could not, because that stipulation, I could not. I am in ad hoc. I am continuing there in the same institution, but for the regular establishment, I am telling that advertisement.
Was there an interim order during the single judges, before the single judge?
No interim order, but on their own, till date, they have allowed these 2 persons. There are 3 persons. Another case is at item 39 in another discipline, that in surgery. These 3 persons, those are continuing on ad hoc basis, they have been allowed to continue, and their post has not been filled up. That is the position before the single judge as well as on today, my lord. That is why my lord have considered this aspect and issued a notice in the matter. My only submission on law is, if a stipulation is not there in the rule, can they input it in the advertisement? Honorable single judge held, yes. That is my resolution. I have given the memo of citation also, the judgments, and at the time of admission, I have given her. I don't know whether it is there or not.
Who's appearing for this?
Mr. S.K. Purohit. That power is there.
You pass it over?
He's a man from Sambalpur. He's a practitioner here. He usually stays Sambalpur. I don't know whether he's there or not. Item 39 is also the same, man.
All right.
Both the cases heard together in one judgment. Can it be?
So then we'll wait at 39, then maybe he'll turn up in 39.
All right, I'm noting.
Just pass. Be taken up at 39.
Quickly list item 22.
22, the order of the Honorable Single Judge disposing of the writ petition, directing the petitioner to file appeal. But one observation is there. The application for renewal has been rejected, and the petitioner
369 days delay, sir.
Well,
there's a delay, unexplained delay of 369 days in filing the present appeal. Accordingly, the delay is not controlled. The writ appeal is dismissed.
Item number 23.
Item number 23. There are 2 writ appeals in this matter. So both are the similar matters related to the road tax matter, which has been.
Other matters keeping on 5th
December. All right. List on 5th December.
Item 24.
Lordship may not say the Honorable Single Judge order, page 66 at page 68, my lord. In absence, the order was passed, but it says not pressed. In my absence, my lord, that was on that date, there is a break bench, as could not appear.
You file a review petition, sir.
My lord? No, my lord. In the, not in the, they have also on merit, my lord, they relied upon another writ petition, whereas opposite petition of 4, my lord, that writ petition was disposed of at the stage of admission, permitting him to file appeal, my lord. Appeal was pending. The appellate order was challenged, my lord. The appellate order was challenged before the honorable single judge, my lord. They regarding alienation of the property of scheduled tribe in the scheduled area, my lord. The alienation totally prohibited, my lord. Alienation was totally prohibited. And I filed an appeal before the ADM. ADM just dismissed the appeal, saying he has no jurisdiction. But before this honorable court, that filed an affidavit, my lord, counter affidavit, saying they are jurisdiction, my lord. The counter affidavit at page 11, annexure 1.
See, you should file a review petition because on the face of it, here it says not pressed.
Yes, madam.
So if you say, no, you did press the writ petition, then you have to go in a review petition, sir. Because we can only go by what is written in the order, the face of the order. Counsel for the appellant now states that
they also, on merit also, have relied upon another writ petition order, my lord. That's it.
Impugned order.
Let's be remanded to the single bench panel. The counter was filed in the writ petition, my lord.
Say the first line of the impugned order, dated 14 March 2018 of the London Single Judge reads, open quotation, none appears for the petition, unquote. And yet the last line of the impugned order reads, open quotation, the writ petition is accordingly disposed of as being not pressed, unquote. If indeed no one was present for the writ petitioner, the question of disposing it off as single quotes not pressed, did not arise. Paragraph. On the above short ground, the impugned order is set aside.
No, I am for opposite party. Your lordship may look at the order. That probably, so earlier an order was passed adjudicating the same matter. The earlier writ petition, your lordship may look at the above line. It is stated that same matter is agitated in the writ application. What happened, my lord?
No, but how can they say it's not pressed when number one is appearing for the petitioner?
This is a wrong, my lord, noted by the. But your lordship may look at the entire order. Only 1 minute, your lordship may give me to explain, my lord. None appears for the petitioner, yes. Mr. Patnaik so and so. Then the honorable judge, honorable single judge, on perusal of WPC number 10,427 of 2013, it appears that the matter has already been disposed of. Original order is an appellable order. He preferred the appeal before a wrong forum. Therefore, the court, while passing the appellate order, says that I have no jurisdiction, but on merit, he has given so many findings. Therefore, this writ application was filed, assailing that appellate order. Then your lordship may look at the writ petition, the order of the honorable single judge earlier. In the writ petition, it is at page 114. Your lordship may look concluding paragraph of the order, the honorable single judge, your lordship may look at that order from the writ application. My submission, he has decided the matter saying that in view of the above writ petition is disposed of with the observation that in case the opposite party number 4 files an appeal, assailing the transfer made in favor of the petitioner, the appellate authority shall consider and dispose of the appeal in accordance with the law. This respondent number 6 was the petitioner. About that observation, his case was that when the court says he has no jurisdiction, it could not have given finding on merit. Therefore, the honorable single judge observed, if this he was opposite part number 4 prefers an appeal, since the order is appealable, without being influenced by that order, independently that appeal should not be prosecuted. Now he has challenged same order, that appellate order in a writ application, which was earlier challenged. Therefore, the honorable single judge has said, in view of the above, the writ petition is disposed of with the observation that in case opposite party number, he has quoted the order in earlier order. In view of the above, the writ petition is disposed of with the observation that in case opposite party number 4 files appeal, assailing the transfer made in favor of the petitioner, the appellate authority shall consider and dispose of the appeal in accordance with law on its own merit without being any manner influenced by any of the observation made by the additional district magistrate Moirabhanj in regulation 2 appeal of number 5 of 2011. It is stated that same master is agitated in the writ petition. So the present writ petition needs no further adjudication. It was observed, the Honorable Single Judge has observed. It is stated that same matter is agitated in this writ petition. So the present writ petition needs no further adjudication. The writ petition is accordingly disposed of being not pressed. This is a mistake on the part of the Honorable.
So after 5 minutes, you have come to the same conclusion we have arrived at. You yourself say it is a mistake.
My Lord, that appellate order itself was challenged. Which order he has challenged?
Whatever, sir. The learned judge will now pass an order after hearing him. That's all. On that short ground, the impugn order is set aside. And writ petition civil 15611 of 2013 is restored to the file of the learned single judge. And will be listed for directions there in the roster bench on January 23, on which date the appellant will appear, as will counsel appearing for respondent number 6. Court clarifies it has not expressed any view on merits. The appeal is disposed of.
Item number 25.
I am appealing for the opposite party.
All right, and appears for the appellant. Discuss now.
Item number 26.
None appears the appellant.
Item 27.
26 and 25.
Item 20. He's in 26. Item 26.
I mean 26.
It was called out just now, sir.
Item 26.
26. May I please? This is a matter relating to the appeals and the single judge order, wherein the single judge has held that the consolidation proceeding does not include the homestead land. And without taking note of the fact that there has been amendment to the Consolidation Act, and as per the amendment, homestead land includes in the consolidation area, and that can be adjudicated by the consolidation authorities. Lordship, kindly turn to the impugn order. The impugn order is at page 18. The relevant portion, I will read it. The dispute between the parties is that they have a property jointly in their name, and they are using that land, a 5 decimal of land, as a passage. Both of them are using, but the land is recorded as Stitivan land, homestead land. I have filed a revision before the authorities and with a prayer to record the land as a private road. Accordingly, my revision was allowed. After making necessary inquiry, it was found that the land is being used by both the parties as a private road. And accordingly, in the remarks column of the record of right, it is recorded that the private road. That has been challenged before the Honorable Single Judge, and the Honorable Single Judge has held that the Consolidation Division has no jurisdiction, Deputy Director has no jurisdiction to decide because the land is a homestead land, without taking note of the fact that there is an amendment. I am reading it out. The relevant portion of the impugn order is at page 18.
Yes.
Considering the rival contention of the parties, this court finds the question to be determined here is for the claim involved herein, involving a request of change of status of the land vis-a-vis granting a relief of use a road, whether the Consolidation Authority has jurisdiction in exercise of power under Odisha Consolidation of Holdings and Prevention of Fragmentation of Land Act 1972 or not. Taking into consideration the status of the land by Annexure 4, that is ROR, this court finds admittedly none of the land involved in Annexure 4 is of agricultural status. Admittedly, this is homestead land. The statement and object and reasons behind the Odisha Consolidation Holding and Prevention of Fragmentation of Land Act
to provides as follows. Then they have noted down the statement and objects. Then, reading the statement of objects and reasons behind the act, this court is of the firm opinion that the Consolidation Act is created in the context of strategy for increasing the agricultural production in the country and to expedite for consolidation of scattered holdings and rearrange the holdings, including fragmented holdings among various landowners, to provide against future fragmentation of holdings, and act to help in economic farming, which are necessary for development of agriculture and increase of agricultural production. It is in the background and statement of object and reasons in framing the act. This court finds the Consolidation Authority has no jurisdiction involving the issue and has no role in changing the status of the land. Looking at the relief contained in the consolidation proceeding, this court finds for an issue involved regarding use of particular land as a road and for the clear appearance of the nature of the land from Patta indicating the kisam of the land as Jalasaya and Gharavadi. Jalasaya in respect of other land we are no way connected. And Gharavadi. This court, while answering the question framed herein above, in the positive observes the Consolidation Authority had no jurisdiction to decide the matter involving consolidation division. Thereafter, I have given the amendment to the Consolidation Act. That is
Annexure 5.
Page 13, answer 5. This
Yes, also the other
consolidation,
side-
this has been amended, section 2G.
I am for the respondent number 1. My lords, I filed a memo that respondent number 1 has died in the meantime, lords.
All right.
Lords, I already filed my counter before. So thereafter, my memo is dated 14/9/2022. I also supplied a copy to my lords.
Yes.
My lords.
It's coming here.
For orders item number 1.
In this case, my lord, the petitioner is a 75 years old man and having.
The instructions haven't been received. My lord calls it next week or whenever my lord is convenient.
Every time we can't be sitting in this combination, please.
Extremely sorry, my lord. We just have to ascertain whether the medical condition that is.
Exactly.
Suffering from paralysis.
What is difficult in that? This is the regular bill, right?
No, my lord, I interim bill is suffering for paralysis in the jails, my lord. So I therefore call for this health condition of the petitioner, my lord.
Seven persons have already been released on
Yes,
bail.
yes, except him, my lord. All have been released on bail, my lord. It is moreover 10 years in jail custody. Old person, 75 years old, my lord.
As he's one of the main accused. He's one of the main accused.
No, main accused.
Jaladhar
No,
Patra.
no. The application says he's been arrested on 9/10/2012. Yeah,
Well, let me see. As in 2020, December 20.
No, he must have been.
Is it a split up trial?
He will know. Sir, is it a split up trial?
No, my lord. Out of 80 persons were facing trial, my lord, 2 persons were split up, 7 persons were facing trial, and out of 7 persons, my lord, 6 persons already released on bail, except him, my lord.
So this is the year, that is why I am asking, because the connected appeal is of the year 2011.
Yes.
This is of the year 2019. That's why I'm asking.
No, he was.
Yes.
As the present accused was absconding after the that is
For instruction, my lord, sometimes I think.
Maybe he is absconding.
Yes, sometimes he is absconding.
Not subscribed.
After absconding in the meanwhile, he may not be in custody.
No, but if he was in
Yeah,
custody,
appeal
since
on
he's
bail,
not
my lord.
well, then
No, thereafter, because he's been arrested after the, thereafter he will remain in custody as whatever he says.
yeah.
He was arrested on 2012, my lord.
Correct.
Appeal is filed lately, or appeal is filed, my
So
lord.
he's been in custody for more than 10 years.
For 10 years.
He's the main accused.
Let's see the order dated 21st of 12/2022. There is a categorical statement with regard to his involvement. The third paragraph. Well, Justice Ratha was part of the bench.
What main accused or other accused is this?
The third paragraph, if I may read, keeping in view the narration of eyewitnesses and the manner in which the offence is carried out, especially the role played by the present appellant petitioner, Jaladhar Patran, whose assault, the hand of the deceased was severed from his body. So it was gruesome.
No, the cause of death is on the head, my lord.
Yes, my lord.
Yes.
And my lord,
As per allegation, the connection is there, lordships. I am not going to that merit, my lord. But there is a
PW6 is the eyewitness. The deposition is on, what's it called?
No, but the point is.
Yes, my lord, it's on medical grounds, my lord, I understand.
Yes, kindly see the
My
PW.
duty to my lord. So,
IE number 1088 of 2022. Constable states some more time for instructions on the present medical condition of the applicant. We'll keep it for Friday next. Every time comes.
Main accused or released on the bail, my lord.
This Friday.
4th November.
4th.
My lord.
All right.
at 2 p.m.
Which one matter?
Chilka matter.
Ah. Okay, we'll
Oh,
call the
after-
Chilika matter. You can wait for a few minutes. We'll finish the Chilika matter and come.
Chilka matter, will continue.
Next.
Matter 6 p.m. Item number 80.
My lords, in item number 80, we have filed the affidavit of the collector Puri regarding the present status and the developments in the meanwhile. And also, last order para 2 may kindly be seen. Your lordship may kindly see last order para 2. In compliance of that, the collector Puri, Mr. Burma has filed, on behalf of the collector Puri, this affidavit has been filed. I think Mr. Burma is also there in BC.
Sir, good afternoon.
Yes, please. Artificial ponds where illegal prawn carries come operation. Right.
Para 3. That the answering deponent humbly submits that the Tahsildar Brahmagiri has reported via his letter number so that the regular patrolling is being carried out by the Tahsildar Brahmagiri, additional Tahsildar Brahmagiri, IIC Brahmagiri PS, ASI, so and so on every alternative day, and found that there is further re-emergence on the previous evicted area for which the Tahsildar Brahmagiri has filed 4 numbers of FIRs in respect of 16 numbers of person via his letter number letter number so and so. Basing on the letters of the Tahsildar Brahmagiri, the IIC Brahmagiri PS has registered 6 number of FIRs by so, along with the copy of the FIR bearing letter number so. And these are all annexed as annexure JZ to Y/9. Then para 4, that the answering deponent states that this Tahsildar Brahmagiri via his letter number so has intimated that the eviction program has been taken from 11th October 2022, 14th October 2022 in respect of the earthen gheri and net gheri at Pandajena, Raipur, Mirzapur Road and so respectively under Panasapada Arai Circle and Gorapur of Arai Circle, Satpada, an area of 168 acres of earthen gheri and an area of 220 acres of net gheris were evicted during the said eviction. The following materials were seized during the eviction and burnt at the spot as detailed below. Net gheri, 40 rounds, bamboo struts, sticks, 600 pieces. The copy of the letter number so. These are the past developments and in compliance of the direction of the Honorable.
My lord, actually, I applied some photographs. All these things are taking place only when I give them the photo. Now, there is a serious issue at the patrolling level. When I give the photos to the collector, he immediately takes action, no doubt. But at the patrolling level, there is a serious problem, which they are not bringing it to the collector's notice that, yes, there are illegal gheris there. All these things, I have supplied them. So it cannot go on for eternity, this thing. It has to stop somewhere. So I have a suggestion for your lordship. Now we have very effective drone systems. So if each district can employ one drone and every alternate day, it can patrol the boundary of the lake. So it will be cost effective and also we will be less rely on manpower. That is what is required, your lordship.
Yes, Mr. Verma.
That is a very good suggestion, sir. We can deploy drone technology, sir, but we need some funding for that, sir. Maybe Revenue Department can be requested to arrange for those funds, sir. And secondly, sir, we have a dedicated WhatsApp number, sir, where people can anonymously file complaints, sir. So, but that number also, we are not actually receiving as many complaints as we expected, sir. So maybe we need to publicize it more and people also need to come forward a little more.
Right.
Sir.
Right.
So far as that part is concerned, they will move the Revenue Department. Revenue Department will get clearance from Finance Department. But so far as the current status is concerned, there is a WhatsApp number and anybody can lodge complaint. If complaint is lodged by virtue of this Honorable Court's order, immediately steps are being taken for eviction or demolition.
But who will write for this?
Lordship, I may be permitted to submit, my lord, on behalf of the intervener applicant, Lordship.
One minute, sir. 1 minute. 1 minute, Mr. Biswal. Mr. Biswal, kindly wait. No, who will write for this?
The
So I will
forest
write-
secretary should initiate it along with the revenue department. In fact, it will be a more cost effective thing rather than patrolling using petrol and diesel and everything.
All right.
Each district should employ a drone an alternate day and they should upload it in their
Because
website.
the coastal side is very long way.
Correct.
So it is not so easy thing to
Within a
keep
few
a
hours, it can be done.
camera, and it will be again, and people will be employed for that. They will get the photographs, and this is all.
Only one person needs to operate.
Technology is quite straightforward.
Only one person you need it to operate it.
Correct.
Can also monitor.
It does not require too much of manpower for that.
Otherwise, even when your lordship is in session of the matter, your lordship is seeing how, despite the eviction, again re-emergence is taking place. So it will go on continuously. It will not end.
That is correct.
So we need something change in our patrolling system.
And another thing,
and they will upload it on the website.
Of the record, I would like to submit before lordship that once the drone comes, the people who are all are accused, they will.
Yes, they can
miss that camera.
No,
even that will be captured.
That will be captured. That is what is required. When they are constructing the gheri, at that moment they should be caught hold of, which is not happening actually.
Lordship, I may be permitted to mention, submit before my lord. Days are not too far when the people of across Chilka will die without food. Lordship, like forest dwellers right, be it in Madhya Pradesh or any parts of India, even taking the honey, the people are suffering in cases since last 15-17 years. The same thing is going to happen to the people of Puri and Ganjam and Khordha, those who are depending directly on Chilka for their livelihood. Even sometimes for catching the crabs, times are coming, the people across the fishermen in Chilka will be arrested for violating the norms on the Wildlife Act. Lordship, what I am proposing, can this be legalized, the prawn culture across Chilka on the beach of Chilka? Can it be legalized for the better interest of the people across Chilka, those who are living in the 3 districts of Orissa? That is, Lordship, the reason for reduction of the fish and prawn culture in Chilka Lake, the authorities there fully aware of this fact. The first reason for reduction of the fish collection in Chilka water, all the connecting point in between Chilka and sea that has been blocked by constructing the road. At 7 points, Lordship, the connecting point between Chilka and sea that has been blocked by construction of the road. Lordship, the construction of the road is good for connecting the one village to another village. But the construction should be done in by making the bridge small size bridge. That can be done. If that in the process what is happening, they have connected the village, one village to another village by completely putting the sand and all these things. Where the connecting water, there is no water movement in the Chilka Lake. The second reason, Lordship, what is happening in the second reasoning for this reduction of these fish and prawn collection in Chilka, the authorities, they are not keeping watch on the issues where these fishes they are used to at the time of month of April, May and June. They should have completely banned the fishing, which they are not following the principle, that policy in strict way. Lordship, the third point is that if at all we are interested for the better preservation of ecology inside Chilka, across Chilka, the Chilka Development Authority, along with the Fisheries Department and the Revenue Department, should have done massive coconut plantation in order to save the ecology of Chilka. These are the principles to be followed, Lordship. Lordship, 40 years back, there was no night at the fishing collection point of Chilka. Be it Baluga, Kalupada, Brahmagiri, Satpada, Krishna Prasad, all these places, there was no night. People are engaged with so much of fish collected there during that time. And particularly one of my clients was telling in 99, he has massive collection of prawn, he could not able to export it, which was collected from that water because of this Indo-Pak war. And during that time, the exchange value of rupee was 40 rupees. Now it is almost 80 rupees. You see, the Lordship, the people across Chilka, they will be die, the prawn culture will be completely banned. Lordship, what do we propose? Let them do the auction. Let them do the legalize this prawn cultivation for the greater interest of the people of Chilka Lake, Lordship. And particularly in my one IA which I have given submitted for Lordship, the state has not filed the counter so far. That
Yes,
is-
yes, we have filed it. He is there, how can I serve copy on 11?
If you serve a copy,
In
then
this case, what happened, that is my recorded land. In that case, without giving any notice,
Copy has been served. Copy.
without giving any notice, they have destroyed my pawn lordship.
no, they filed a reply, he says.
We have filed the reply. Copy has been received on 12th October 2022. We have served copy on him. We are having the memo receipt.
12th October, you have served the copy. I think, all right, lordship, I will file a rejoinder in that case.
Okay.
All
Then
right. Just put down
13647 of 2021.
IA 13647 of 2021. Mr. Manti states that he has filed a reply today.
No, we have already filed. Copy has already been served.
Reply is here.
It was e-filed on 11th October 2022.
I see. You say, then you just take
Then I
this.
can file the hard copy.
All right, the reply if state is on record, rejoinder be filed before the next date. In the main writ petition, you say an affidavit has been filed.
1 by 67, lordship. IA 141 by 67 by 22. In this
Yes,
case,
yes.
lordship, what they have done, the Tahsildar,
141.
lordship, in this case, what they have done, the landowner is Anjali Sardar, one lady. She is having acres of land. No notice, nothing
There
of
is
it.
no such IA. There is no such IA. You see the last order, para 12. These IAs are to be taken into consideration today. Para
Lordship,
12
this
of the
is
last
14th October 22. This Anjali Sardar versus Investment and others.
14th October. Recently he has filed.
Which is the number, sir?
14167 by 22, lordship.
You kindly serve a copy to us.
We have 14163 we have.
Yes, lordship, that copy, and this is 14167 by 22. The copy has been served. All right, lordship, I will serve
No,
another
but-
copy during the course of the day.
It's not tagged here today.
Lordship, let it be come in the next week and next day.
Correct.
Let me serve the copy in the meantime, lordship.
All right. In the main writ petition civil 7469 of 2017, an affidavit has been filed on 26th October 2022 by Mr. Samarth Verma, learned collector and district magistrate Puri, pursuant to the order passed by this court on 15 September 2022. Full stop. Details of the FIRs registered pursuant to the eviction drive undertaken by the authorities on the basis of the information provided on the previous date have been set out in the affidavit. Paragraph, the learned amicus curiae suggested that the local administration in all the 4 districts of Ganjam, Puri, Khurda and Kendrapada should use drone technology to keep a tighter vigil on the prawn activities of illegal prawn gheris, which suggestion has been welcomed by the collector Puri, who states that he will write to the state government for adequate funds to be provided for that purpose. The court would like the state government to immediately consider the above proposal and make the necessary funds available to all the 4 districts, which will require intensive patrolling to be kept up in order to check the re-emergence of illegal gheris in places where they've been demolished and for emergence of any new illegal gheris in the 4 districts. Anything else?
Lordship, para 11 of your lordship's order regarding the pollution.
Para 11, for compliance of that, we need some time. It is 15th November, I think, 2 months time. Para 11, sorry.
Next date.
Para 11 will comply with the meeting, that meeting.
As regards
Kongwa,
the holding of the meetings by the state pollution control, by the state government, with the State Pollution Control Board, the BMC, and the Resident Welfare Associations. Mr. Mohanty, learned AGA, states that some more time may be granted to the state for that purpose.
Actually, yes.
My lord,
The
may
problem
I
here is that
request one thing,
your
my lord?
lordship may see that there are no resident welfare associations. It is the promoters
was appearing
who are
that.
managing that.
Somebody
in that case, we have seen these associations cannot be formed. The promoters, without taking NOC from the pollution board, now the BDA is issuing occupancy certificates, which should not be done. And they are discharging this water, untreated water.
My lord,
actually, here
may
the
I request
promoters are at fault.
BMC may be noticed in this case because BMC is not noticed. So, and or your lordship's order may be communicated to the BMC.
Yeah, a copy of this order and the previous order dated 15 September 2022 be communicated to the chairman, Bhubaneswar Municipal Corporation.
Not chairman, commissioner.
Commissioner Bhubaneswar.
And SPCB also. State
as well as the SPCB, forthwith.
Right. Lordship, last two occasions also directed.
My lord,
Last two occasions.
my lord, towards the bottom, 4 writ petitions are there. I have filed the 4 writ petitions. Interim order your lordship has granted. The counter has been filed by the CA as well as the Tahsildar. The copies of the counter affidavit has not been served in 4 cases too.
Or in the connection with petitions, copies of the counter affidavits be served on counsel of the petitioner, who is permitted to file the rejoinder of the next state.
Last two occasions has
Interim order to continue. Yes, I've just said that. I have said that, sir. Yes.
Last occasion, a lordship directed revenue secretary to form a Chilica policy because this eviction demolition cannot be a regular phenomenon, lordship. Rightly, lordship directed to come up with a policy to safeguard the entire Chilica lordship. So in that aspect, lordship, government
will inform
para
the court.
Para 5 of the last date's order.
Of the progress made in implementation of the directions issued in para 5 of the order dated 15 September 2022 on the next date.
Lordship, your lordship has granted two months time from the last date, lordship. That is on 15th September, lordship. The Chilka Development Authority, Revenue Department, and the Wildlife Department, lordship. The persons, those who are directly involved in this case for formulation of the policy, let them be involved the local communities of that area, lordship, in all the 3 districts, lordship. That is my submission on behalf of the people across Chilka, those who are depending on their livelihood.
Then it will doubt. If this thing will be adopted, it will not be worked out. Your lordship's order cannot be gone. Let us first sit, all the officers and all the departments
Let
should
them
sit together.
take a decision first.
Let them take a decision. If possible, then we will involve the.
No, otherwise the entire issue will be.
Otherwise, it will be a mess.
5th December. Go back.
In this matter, the Lawrence single judge, without taking note of the fact of amendment to the Consolidation Act, has decided the matter on the basis that homestead land cannot be considered by the land acquisition by the consolidation authorities. That is the
right. And then you said the amendment was
amendment. Amendment. I have annexed copy of the amendment. I have annexed 5.
Correct. What do you say? You were saying something.
No, Lords, your Lordship may kindly have a glance to Annexure 5. What my Lord senior is, Lords. First of all, my Lords, my objection, I have already filed my counter. Lords, this is arising out of an application under Article 227, my Lords. So writ appeal is not maintainable. That is my first submission. And so far as Annexure 5 is concerned, your Lordship may kindly see. Page 14. Notes the proviso, perhaps my Lord and Senior is Lords, page 14. Proviso, my Lords. Provided that no permission of the consolidation officer shall be necessary for transfer by way of sale. Lords, first of all, 2, which is Lords, notwithstanding anything, any law for the time being in force, no landowner except with the permission in writing of the consolidation officer previously obtained shall, after publication of the notification under subsection 1 of section 13, transfer by way of sale, gift, mortgage or exchange any land, and no document purporting to effect any such transfer shall be registered by registering officer appointed under the Registration Act unless document is accompanied by a certified copy of the aforesaid written permission. Now, Lords, then proviso. Provided that no permission of the consolidation officer shall be necessary for transfer by sale, gift, mortgage, or exchange of lands which are covered by orchards, groves, or homestead lands. So, rather, it excludes the homestead lands, Lords.
Now, this is not a case of transfer. They say whether for the purpose of publication of a record of right, whether within the consolidation area, whether homestead land can be considered by these consolidation authorities. That has been, what is consolidation area? That has been defined in 2G. 2G earlier, there was homestead land, orchard, tanks that are not included.
Let it go back to the single judge to consider this amendment.
Yes, that is what I'm telling.
One more thing.
Let it be considered by a single judge on merit.
One more thing I would like to submit, my lords. Your lordship may kindly have a glance to section 2F, my lords, of the Consolidation Act. Lords, 2F.
Yes, please.
Consolidation. Consolidation means amalgamation and redistribution of a parcel or parcels of land comprised in different holdings of a unit for the purpose of rendering such holdings more compact. Now, lords, explanation 1. Lands which are covered by orchards, groves, or homesteads by the date of publication of a notification in the official gazette under subsection 1 of section. Lords, explanation for the purpose of this clause, holdings shall no include the following.
Yes.
So, homestead lands are not lords included. And lords, fact remains, lords, consolidation operation, lords, over by 1983, lords. Now, in the year 1984,
single judge consider the effect of this amendment.
Now, lords, in the year 1984, this appellant himself, lords, filed an application before the Tahsildar. Lords, order I have annexed. That is, lords, at page 6 of my counter, my lords. I have annexed the order passed by the Tahsildar, my lords. He himself, my lords, has applied before the Tahsildar to note a share note in respect of that particular piece of land, my lords. And after lapse of, my lords, my lord may kindly have a glance to Annexure A1, my written note of submission submitted before the Honorable Single Judge in the writ petition, my lords. Now, in the year 1998, after lapse of 15 years, lords, he approached the consolidation officer when he himself, my lords, had approached earlier to the Tahsildar for share note, my lords. In mutation case number 488 of 84. Now, lords, it's a homestead land. Consolidation operation does not, lords, cover the homestead lands, lords. If your lordship will see the object and reason state that that Honorable Single Judge has quoted in the impugned order itself.
How do you interpret this amendment? See, that's only the amendment which portion you read out only applies to sales and transfers.
My lords, that lord supports me, my lords. That excludes homestead. So
no. That only for sale and transfer.
Even, my lords, even section 2F, which I have read out, my lords, just now. Section 2F, my lords, explanation 1.
No, which is why you need to see the amendment, right?
Lords, I'm lords, updated lords book. I'm lords, I'm reading out, lords. This is after amendment, my lords.
No. This page 14.
Page 14, my lords.
The main portion only talks of transfer, bewaif, sale, gift, mortgage, or exchange of land.
Yes, it doesn't cover that consolidation.
Here we're not talking of either sale, gift, mortgage, or exchange.
That my lord, scenery is, my lords, relying, my lords. That my lord, scenery is relying on the very same section that consolidation authority have the power, my lords. That I'm submitting that it is not, it doesn't apply to homestead lands, my lords.
Let it be examined.
Lords, section 2A.
Yes.
I'm not permitted to again read out. Section 2 of consolidation. Consolidation means amalgamation and redistribution of parcel or parcels of land comprised in different holdings of a unit for the purpose of rendering such holdings more compact. Now the explanation. For the purpose of this clause, holdings shall not include lands which are covered by orchards, groves, or homesteads. So homesteads are not covered under the consolidation, my lords.
Yes.
My understanding, I'm placing your lordships. Lordship, kindly turn to answer 5. What the amendment?
Yes.
Page 13.
Yes.
2G was amended. 2G is consolidation area. So what is the consolidation area? It is to be notified by the government. This area will come under the jurisdiction of the consolidation authorities. So consolidation area means the village or villages in respect of which a notification under subsection 1 of section 3 has been issued and includes the land covered under explanation to clause F. So under explanation clause F, that land will include within consolidation area. So clause F means what we are expressing, the lands which are covered by orchard, groves, or homestead lands by the date of publication of the notification. So by way of amendment, all the 3 orchard, groves, homestead land now included in the consolidation area. That is the amendment. In view of this amendment, now homestead land record of right can be published by the consolidation authorities. Not the holding means agricultural land holdings, chakka. That cannot be from homestead land, cannot be a chakka. But ROR can be published. That has been amended.
The ROR has been published.
The implication of the amendment is not understanding.
ROR has been published.
Now ROR has been published in the remarks column. Instead of private road, it is written as Gharawadi, homestead land. That is what only my prayer is only to record it is a private road. And that has been allowed and that has been corrected. He is challenging only to that correction only.
And my lords, correction is required if the consolidation authorities have committed any mistake or error or wrongly it is published, my lords. Now, my lords, it was earlier prior to the consolidation operation, it was homestead land, and after the publication, it was also homestead land. And he himself, the appellant himself, approached the Tahsildar after the consolidation operation was over, after the pota was issued. Appellant himself has approached the Tahsildar. Now, my lords, which order I have annexed, your lords, you have seen. Lords the appellant himself approached to the Tahsildar that he has 50% share over the said land and his share not may be lords done in the ROR, lords, and that has been allowed since 1984. And after lapse of 15 years, lords, he has approached the revisional authority for correction of the ROR when there is no mistake in the consolidation ROR. Or if there is road, lords, he could have approached the civil for declaration the property as road, lords.
The challenge in the present appeal is to an order dated 19 March 2018 passed by the single judge in OJC number 13450 of 2000. Whereby, while allowing the writ petition, and setting aside the appeal order dated 7 November 2000 of the director consolidation. In consolidation revision case number 2722 of 1998, the learned single judge observed that since the land in question was a homestead land, the director consolidation lacked the jurisdiction to decide the matter involved in exercise of the powers under section 37(2) of the Orissa Consolidation of Holdings and Prevention of Fragmentation of Land Act 1972 (Act). In coming to the conclusion that homestead land was outside the purview of the above act, the learned single judge perhaps did not notice the amendments made to the act by the amendments notified on 16 March 1989. Stop. By virtue of these amendments, according to the counsel of the petitioner, it was possible for the director consolidation to effect changes in the ROR pertaining even to homestead land, a point which is disputed vehemently by counsel appearing for the respondents. Be that as it may, it is apparent from the face of the impugned order dated 19 March 2018 that the learned single judge, the attention of the learned single judge was perhaps not drawn to the Amendment Act, and in particular the above amendment provisions and the effect of such amendments on the issue on hand. Consequently, without expressing any view on either of the contentions of the parties as recorded above on the amended provisions, the court, while setting aside the impugned order of the learned single judge dated 19 March 2018, restores OJC number 13450 of 2000 to the file of the learned single judge for being once again considered afresh in light of the above amendment provisions. Full stop. The court clarifies it has not expressed any view on merits. The writ petition will now be listed before the roster bench of the learned single judge for direction on 10th January 2023, on which date both parties will appear. Considering it's an old matter, the learned single judge is requested to proceed with the disposal of the said writ petition as expeditiously as possible and preferably within a period of 6 months thereafter. The writ appeal is disposed of.
My interim order was there. I pray that interim order may continue, otherwise he's making construction over the same.
All right. The interim order passed by this court on?
The interim order was passed on 16/8/2018. 18/6/2018. 18/6/2018.
The interim order passed by this court on 18/6/2018 will continue during the pendency of the petition before the learned single judge.
Now the respondent number 1 has died in the meantime. Let him substitute him, lords.
Right.
Item 27.
May please, your lordship. Lord, here I am challenging the order of the Honorable Single Judge under Annex 2, my lord, at page 77. Whereby, my lord, the appellant corporation has been directed to pay the arrear salary of the two writ petitioners from 2009 till date. In fact, my lord, if your lordship would turn to page 79, that's the impugned order, my lord. 79.
79, is it?
My lord, page 79. That's the impugned order, my lord.
Yes.
Here, my lord, the two writ petitioners, in fact, were working as enema account helper in the appellant corporation in 96, my lord. In 2000, these two writ petitioners were, my lord, they were appointed as assistant accountant.
1 minute. No date fixed. Old matter. Actually, I'd asked them to give preference to all. We have a long list today. This will take some time, I think. This will take some time.
I think it may not take time also. For milers, it will take only 1 minute time. Well, kindly have a glass to page 81.
Yes.
Well, so their contention in counter. Well, so my honorable single judge quoted it. That in reply to averment made in paragraph 6 of the writ petition, it is amply submitted that the opposite part number 2 has declared the petition as surplus category of the employee through letter dated 26/12/2005.
and the authority has decided to retrench the zero surplus employee, since the case of the petitioner is pending before the Honorable High Court, they have not been retrenched. And that was filed, that affidavit, my lords, was filed in the year, my lords, 2018. They themselves admitted Honorable High Court, considering that observation, has passed that order. Now, my lords, about that law, well settled, my lords, cannot be developed, my lords, after Mahendra Singh Gill case, and this law is already well settled, my lords. Now they are trying to just dilute this statement, whatever they stated in the counter, filing additional affidavit, additional some subsequent affidavits, and all these things. And that too, my lords, in the meanwhile, that original writ application where we have challenged about this, my lords, reversion, that has been quashed, and the petitioners have been allowed to continue, they are continuing in the service. This is the order, my lords. The Honorable High Court has already, Honorable single bench already passed this order, and they are continuing. Up to 2009, they have paid, because my lords wanted, the court wanted that that should be clear, and they paid. And 2009, I don't understand. There is no restriction order, no revision order, nothing. And you yourself admitted that they are continuing and they have not been retrenched.
No, this is for assistant accountant.
Same petitioner, my lords.
Commerce, assistant accountants, commerce.
Commerce.
Same. But here the Honorable Single Judge has directed them to be observed against the vacant post. What has happened?
No, that is a different concept. Concept is that they have come against the order of reversion. First page, my let's kind of glance first page. Against the order of reversion, we have come before the Honorable Court. There is a status quo order, and we continued all throughout. I don't understand 2009, where from that 2009 order came. And they said that there is no such order in 2009 that you will continue up to that level, or the interim order of the Honorable High Court has been modified. In this particular writ application, we prayed for the arrear claims. That's our salary component. There, the counter was filed. Counter categorically stated that if these people they are continuing, we are unable to retrench them because of the interim order. Now they have come forward and said that we will not pay the wages salary.
In 2000.
Now what they are doing is they are trying to expand this postman's topsy-turvy the situation, filing affidavits after affidavit. Which quite aware of that position of law settled by Honorable Supreme Court in Mahendra Singh Gill case. They cannot develop. Once you have stated something, you cannot change it in subsequent stages.
What we have placed before the Honorable Single Judge. In 2016, this writ application was filed claiming arrear salary. Now, in January 2017, the corporation has filed the counter affidavit. The Honorable Single Judge felt that since the counter affidavit is not categoric as to which up to which writ petitioners have worked, the Honorable Single Judge passed interim order directing the corporation to file additional affidavit categorically stating up to which date these two writ petitioners have worked. Now, an additional affidavit has been filed. Along, that document is at page 74, my lord would find at page 74 that these two writ petitioners, they have worked up to 2009. Now, in the writ petition, arrear salary was claimed from 2005 onwards. Now, in March 2017, the Honorable Single Judge directed you file specific affidavit up to which period they have worked. We have filed specific affidavit that they have worked up to 2009. Honorable Single Judge directed you pay from 2005 to 9. We paid. Now, thereafter, the Honorable Single Judge disposed of the writ petition by taking our averment in the counter affidavit that they have not been retrenched. So, they have worked, you pay.
If it's a fact that they have not been retrenched, why would you not pay?
For that, I was placing those two first 2000 OJC matters. In fact, what has happened, 96, they were engaged as NMA. In 2000, after they being in 2000, January 2000, they were appointed as assistant accountant. Now, down the line, about 6 months thereafter, pursuant to directions from the government that you need to take austerity measures and all, order of reversion was passed in 2000, which they have challenged in OJC, and that number is there. They have challenged here, and order of stay was passed. Then in 2006, again, pursuant to directions from the government, the post of assistant accountants, about 27 posts were, initially it was 47, then it was made to 27. These two writ petitioners, they were categorized as surplus workers. Now they again filed a writ petition, got a stay. Now, in 2016, when those two writ petitions were pending, in 2016 they approached that you pay the area salary from 2005 onwards. So now, my lord, up to the period up to which they have worked, no work, no pay, my lord. So the honorable single judge, that is what directed, you say categorically up to which period they have worked. And that is what we have categorically stated they have worked up to 2009. After filing the counter affidavit, we have filed additional affidavits bringing on record.
But the single judge notes what you have said in those affidavits.
Yes, my lord. Single
you
judge
say that this has not been retrenched.
That honorable single judge insinuates from the statement that they have not been retrenched.
Look, so insinuate. You have actually said they have not been retrenched.
Yes, but they have not been retrenched and they have not worked.
No. Now you're adding that.
That's how it is, my lord. I cannot.
That's how it is. Words, my lords. That is not what is there, my lords, in the counter.
You see, the appeal is directed against the order dated 15 January 2018 passed by the learned single judge, disposing of writ petition civil 19546 of 2016. Directing the appellant to pay the arrears of salary to the respondent. To taking on board the averments made in the counter affidavit filed by the appellant to the effect that the writ petitioners had not been retrenched and are continuing the job for which they were entitled to get arrears of salary from 2009 till date. Paragraph. In para 8 of the impugned order, the learned single judge has extracted para 5 of the counter filed by the appellant corporation, where it was stated as under page 81 top. Mr. Party learned counsel appearing for the appellant does not dispute that the above averment was made in the counter affidavit. But took exception to the direction that they should be paid the arrears of salary for the entire duration of their continuing in service. Paragraph, if indeed, even according to the appellant, the respondents had not been retrenched on account of the pendency of the petition before the High Court. Which petition was this?
WJC number 8539 of 2000. Page 19, 19 of the writ appeal.
Yeah, that is OJC number 8539 of 2000.
Yes.
The impugned direction of the learned single judge cannot be altered. First of it may be noted that the said OJC number 8539 of 2000 was in fact disposed of on 10th January 2019 by the learned single judge, directing absorption of the writ petitioners therein in the appellant corporation. Has this not been appealed against?
No.
It appears that the appellant has not filed any appeal against the above order dated 10 January 2019 in OJC number 8539 of 2000, which has therefore attained finality. Paragraph. In the above circumstances, the court is of the view that the impugned order does not suffer from any legal infirmity which calls for interference. The writ appeal is accordingly dismissed.
Equilibrium 28.
28 lordship on behalf of J.K. Mahapatra pray for 2 weeks time.
For what?
He has some health issues. He has not come forth.
Mr. Counsel appearing for the appellant is stated to be unwell. Just on 21st February.
Your lordship, one IA has been also filed by the state and the copy has not been served.
Who is the state counsel?
IA. Yes, I'm
Item 29.
None appears dismissed.
Item 14.
My lord, there's a case where I'm challenging the order. That the first is that, my lord, in the advertisement, is there the appointment to the post of multi-purpose assistants, my lord, annexure 1, page 15, where the minimum educational qualification prescribed 10+2 pass, my lord. Qualification 10+2 pass, and preference will be given to commerce stream having computer proficiency of O level with use of Odia language in computer. That is the post required the qualification. Then the petitioner applied for it, but one
So
diploma holder.
You're continuing in service now because of the interim order.
My lord.
You're continuing in service because of the interim order passed in the writ appeal.
No, I'm not. They have not given to me. They have not selected me.
Now, what is this interim order?
Well, interim order is that judgment of the single bench has been stayed. Single bench.
What does that mean?
What does that mean? Because, my lord, single bench, as my lord, in this case, compared both the candidates, which is not the duty of the court, my lord. They have paragraph 33.
So, no. A dismissal order being stayed, I've not understood. What does that mean?
I am the petitioner in the earlier writ application. I have challenged the consideration of the candidature of my opposite party, individual opposite party, that he cannot be considered for the post because he has no 10+2 pass. But this honorable court extends that it is equivalent to 10+2 and decided that he is a better candidate by comparing both candidates.
No, and so your writ petition was dismissed.
Yes. No. Against that, I have before a lawsuit.
No, what does that stay of a dismissal order mean? I don't understand. This court, when we issue notice,
he cannot be also be considered for appointment because he selected and he stood fast in the merit list, where he has no educational qualification as per the advertisement.
No. When this court passed an order on 10th May 2018,
my lord,
we directed the operation of the judgment and order dated 25th April 2018 passed in writ petition so-and-so shall remain stayed.
My lord.
What does it mean?
My lord, in my understanding, not to give appointment to
No. When you failed in your challenge, how can it be that the other person can't be given appointment?
My lord, kindly see, while dismissing the writ petition, the court since finds the petitioner who appeared at second position in the provisional merit list was kept as fast waiting candidate in the provisional merit list prepared in the year 2016. The court therefore observes, in the event the term of his class not expired in case any future vacancy and
only that has been stayed, which means what little relief you have got, that has also got stayed.
Well, that considering the candidature of that
not opposite party, in case there's a fury and you are not employed in the meanwhile, you may be considered. That is what the order says.
My lord, in my understanding, my lord, kindly see that opposite party number 4, who has no eligibility as per the advertisement.
But there's no direction favoring opposite party number 4, which requires to be stayed.
That is the whole case, my lord.
Kindly, by the single judge. What I'm saying, the single judge has not granted. Yes. Basically, single judge denied you relief and granted you remitted relief, saying if any future vacancy arises and you're not employed.
That is my to some extra.
But that has been stayed by the division bench.
Para 5 is the my lord order. In the page 32, para 5. See, learned counsel appearing for the private opposite party number 4 on reiteration of his client's response to the counter affidavit filed here, referring to documents accompanied therein, as well as the documents accompanied the counter by opposite party number 2 and 3, and as referred in herein above, while justifying the process of selection and consideration thereof, contended there is no illegality or infirmity in the selection process requiring any interference with court. Yes. Considering the rival contention of the parties, this court finds the petitioner is a 10+2 pass holder, whereas the private opposite party number 4 is a 10+ diploma holder. Looking to the documents appearing at annexure A/3, the counter affidavit, it appears the document clearly indicates that by letter number such and such, it was clarified by Secretary Council of Higher Secondary Education, Bhubaneswar, that 3 years of diploma engineering in different streams conducted by the State Council Technical Education and Vocational Training Odisha with foundation subject like physics, chemistry, mathematics, and English has been treated as equivalent with 10 plus 2 science conducted by CSC Odisha with effect from 16/11/2013. This letter further disclosed, while issuing such clarification, it was also intimated that the department is awaiting a further clarification as to how to treat the candidates having equivalent qualification prior to 16/11/2013 and applied for the post having +2 or equivalent qualification. So from this communication, it becomes clear that there is already a decision at appropriate level for treating the diploma holders in the particular subject in science stream to be equivalent to +2 science, except a clarification on the treatment of candidate prior to 2013. This communication was followed with notification 25/6/2014 appearing annexed B/3 of the counter affidavit and opposite party number 2 and 3 indicating therein that the Council of Higher Secondary Education Bhubaneswar recognized the examination like 3-year diploma course in engineering branch conducted by SCT and VT. Odisha has equivalent with +2 science stream conducted by CSC. Odisha having foundation subject like physics, chemistry, mathematics, and English with effect from the date of issue of the said order. It is under the circumstances the court finds there is clear decision of the government in appropriate department to treat 3 years diploma in engineering subject qualification in par with that of +2 science in particular science subjects. There is no statement forthcoming regarding any challenge to this circular communication by any concerned as of now. This court therefore observes that there is sufficient intimation to the general public, including the applicants, regarding treatment of diploma as equivalent to +2 science. It is at this stage this court finds the advertisement involved herein was brought out on 17/11/2015, much after the above communication, and it is nobody's case that decision on equivalence was taken during consideration involved therein. For the existence of circulars much prior to floating the advertisement involved herein, the indication or no indication on the advertisement regarding consideration of +3 diploma candidates for the purpose to the view of this code becomes redundant, particularly for treating the diploma equivalent to +2 science came into force much before the selection process was initiated. At this stage, looking to the...
So what is wrong with the order?
Because, my lord, that this is for the existence of the circular much prior to the advertisement involved therein, the indication or no indication in the advertisement regarding consideration of +3 years diploma candidate for the purpose is, my lord, that is not that +2 or any equivalent. The advertisement specifically stated only +2 pass out certificate. My lord, I have cited 2 judgments before the Honorable Single Bench that even if there is a equivalence in the advertisement, if it is not in the original rule, so that equivalence also cannot be considered.
No, but here it's the other way around. The circular is already there in force even before the advertisement recognizing equivalence. It is simply not mentioned in the advertisement, that's all. It's the case.
That is the whole case of mine, not simply. It is, and not in the rule itself. This D/3 in the counter they have filed. My lord, and just for, my lord, just bear with me for a moment. From the comparison of marks, it clearly appears, the single bench, my lord, Honorable Single Judge, the private opposite party number 4 is a better candidate. My lord, is it that court can decide that who is a better candidate? And better candidate, and the petitioner herein, to make it more specific, the petitioner has secured 53 marks in HSC and +2 where opposite party number 734 marks, and how this physics, chemistry, and that's all they have taught, and that has been compared within the, that is, my lord, I think that comparing both the candidates' merit should be refrained from by this honorable court, my lord. And furthermore, my lord, the advertisement does not say that any equivalence will be there. And so there I have decided, I have cited one judgment, my lord, that as according to the advertisement that should be filled up. That is, cannot be any other method, my lord. That is, consequently, when a particular my lord, may I read, my lord? And there is no also relaxation clause in the advertisement, that there is a relaxation power, or that government can say that by using that power we have done it. So simply, my lord, to show any favor to some diploma holder, this selection process has conducted. My lord, that is Berenga Talukdar in case, my lord, the Supreme Court said, no, what is the strictly in accordance with the advertisement? If advertisement does not speak any equivalence, so you cannot give that equivalent even if that is there in the file. And furthermore, my lord, and another judgment which is said, Prakash Chandra Singh Meena, if the rule, the guideline or rule, which is the source of this appointment, that is not mentioned any equivalent, so it cannot be taken, my lord. In the matter of eligibility qualification, the equivalent qualification must be recognized as such in the recruitment rules or government order existing on or before the initiation of recruitment process.
There is a government order.
This is not in the recruitment rule. It has not been mentioned.
No, but you're just reading it in half. The equivalence must be recognized in the rules or through a government circular even before the advertisement is issued. And that is satisfied here.
So no, in the rule, it is not there. My lord, it's not.
It's there in a government circular. The circular recognizes.
File. We don't know, my lord, where from it has come. Otherwise, I would not have applied. If it would be there, my lord, and Honorable Single Judge stated that it is within the wide circulation and it is the public knows about it. And what is the source that in the counter first time they have filed it? In the advertisement it was not there. That is a wrong finding, my lord. That it is no challenge to that because it is not within our knowledge that this has ever in the file of the government that it is declared equivalent.
Right. All right. The challenge in the present appeal is to an order 5th April 2018, passed by the 25th April 2018, passed by the learned single judge, dismissing writ petition civil 6271 of 2016 filed by the present appellant, questioning the appointment of respondent 4 as single quote Gram Rozgar Sevak pursuant to an advertisement dated 7th November 2015. Paragraph. One of the required qualifications was that the candidate
C, my lord. Page 15, C, qualification.
should have been a 10+2 pass. Full stop. Preference was to be given to commerce stream having computer proficiency of O level with the use of Odia language in computer.
My lord, one more point, my lord, I'm sorry. That selection will be based strictly on basis of marks obtained in the SC and +2. And there is a diploma is on a different syllabus and +2 is in a different syllabus. So the whole marks is 16, here his only marks is 700. So there is no comparison between two mode of certificates, my lord, who is a better candidate, because this is not the same. This selection will be strictly on basis of marks obtained in the HSC and +2. And HSC is only 900 and +2 is 700 and C is at 1600 diploma. And how can you draw a comparative who is better?
We'll dictate the order later. The writ appeal is dismissed.
My lordship, these judgments, my lord, is in accordance with the judgments I have cited. Lordship may refer that.
Definitely. All right.
Item number 30.
30, I may appeal for the respondent. All right, none appeals for the appellant. Dismissed.
Item number 31.
Here, my lords. The petitioner is challenging the.
But item 31 may be taken up next week. Let the appellant be served a copy of the writ appeal. It is not resolved.
I have already served. I will serve again.
All right, another copy to appeal be served on counsel appearing for the respondent.
The interim order may be continued, my lords.
Interim order to continue, list on 14 February.
There is the interim
Item
stay, my
32.
lords. Now, other matters, item 46 to 53, those are connected matters.
All right, same, 46 to
This is
53. Same.
one judgment, my lords.
All right.
46 to 53, my lords.
All right.
Item 32.
32, my lord, in this case, our instruction is that petitioner appellant died in the meantime. So we'll file substitution and waiting for that.
It is stated that the appellant has expired and counsel for the appellant seeks leave to file an application to bring the legal representatives on record. List on 15 February.
Item 33.
My lord, item 33 also similar clear. In the meanwhile, petitioner appellant is dead.
All right.
2 weeks time, we can be given to file the
What's the
substitution.
delay? No delay as per SR order. All right. You just see similar order. The appellant is stated to have expired.
15. Item 34.
Your lordship say pray for a passover.
It's a delay.
Item 35.
May I please, your lordship. The petitioner is challenging the order dated 2/5/2008 passed by the non single judge, your lordship, in WPC number 23133 of 2014, your lordship. On two grounds, your lordship. First ground is the before giving the direction to give resignation, your lordship, the opposite party have not issued any so cause to the petitioner. Although the London single judge admitted this fact, but not consider, my lord. And second thing is that while the selection committee prepared the second merit list, they goes against the declaration given by the opposite party number 6, your lordship. Your lordship, facts of the case is that 15 candidates, including the present petitioners and opposite party number 6, Jogana Swayaka Patua Palu Gram Panchayat, your lordship. And your lordship, kindly see the page 17 and 3. Your lordship, after calculation of mark, 3 persons were selected, your lordship. Annexure 4, page 18, your lordship. Manjusri Mahakur, Gargawa Biskal, the present petitioner, and Sanjukta Mishra, your lordship. This is the first merit list, your lordship. Manjusri Mahakur was given appointment. After some days, he gave resignation, your lordship. After the resignation of Manjusri Mahakur, the present petitioner was given appointment, your lordship.
Who's appearing for the Sujata Mishra of respondent number 6? Is being served. Mr. Amitabh Tripathi, where is he? Although one Mr. Amitabh Tripathi, advocate, has entered appearance on behalf of.
Kindly a passover, my lord, on behalf of opposite party. I will intimate him.
I know. Today there's no time for that. He does not appear on the first call. In the interest of justice, list on 20th February, interim order to continue.
At note 36.
None appears dismissed.
At note 37.
37 not pressed. Not pressed, dismissed.
Item 38.
None appears dismissed.
Item 39.
This was to come with that earlier matter.
Yes, the 21.
21.
Ah, So again, nobody's appearing. So Mr. Purohit. Mr.
It is like
Purohit
next week I will intimate.
was entered appearance on behalf of the respondent institute. He was not appearing despite a passover. In the interest of justice, list on.
Early date. I will intimate him over telephone. I could not get his phone number.
What's the hurry, sir?
Because they are continuing on ad hoc basis. They have to get a regular appointment. If they succeed.
9th February.
9th February.
9 January. All right. 9 January. All right.
At or 40.
Along with the 21 and 39, both are sent.
Correct.
My lord, item 40, I am BC, my lord. My lord,
Yes.
I have challenged the order of the Summer Court dated 6/2/2018, my lord. Passed in position number 11774 of 2000. That point, it has been pointed by registry that certified copy has not been filed, my lord. I filed the authenticated copy which was communicated to the school, my lord. Therefore, it is not necessary to file the certified copy at all.
Delay of 92 days.
Delay is 92 days. I was not a party in the writ petition. After communication, when I came to know that this copy has this order has been passed, I filed the writ petition.
You are appearing.
I filed the writ appeal, my lord. Therefore, according to me, actual there is no delay, but in abundant person, I have filed this petition for condemnation of it. Only 1 point here there.
Because IA number is taken on record. The certified copy is dispensed with, applications disposed of.
My lord, on merit,
So-
my lord, one thing, my lord, your lordship can dispose of the writ appeal, my lord. Lordship kindly is an approved staff. The opposite party now respondent number 6, my lord. Respondent number, my lord, only 5 is an approved staff. And as the district inspector, the district education officer directed to terminate his service, the headmaster terminated his service, my lord. The termination order was set aside. At the time of setting aside the termination, honorable single judge directed the school authority shall pay the salary 75% of salary for termination period, my lord. That period he was not in service. So lordship kindly come to page 37, my lord.
Yes.
My lord, towards bottom, my lord.
But however, considering, yes.
Now, as considering the submission of Lord Counsel for the petitioner, finding that submission has a strength based on the opening of service book, and further, as this court finds, the termination or disengagement order has been issued even without initiation of any proceeding involving the petitioner or assigning any reason for discontinuance of the petitioner. The impugned order is not sustainable in the eye of law. Law is also fairly settled that no regular employee can be issued with a marching order without putting him at least with a show cause. As a consequence, this court interfering with the impugned order, who violated Annex 8, sets aside the same and directs the school authority opposite my court to reinstate the petitioner to the post as he was holding the time of termination. But however, considering that petitioner has not worked all through, and this court interferes in the discontinuance order after 18 years, this court the school authority, my lord, to release at least 75% of back wages and other benefits to which he is entitled to within a period of 2 months from the date of communication of the certified copy. He is an approved staff, my lord. The agent education school authority means managing committee, my lord. Managing committee is not liable to pay. The state authorities are liable to pay that 75% of back wages. He is not a management employee, my lord. He is an employee, and his service was.
No, this is a granted institution, is it?
Granted school, my lord. That we took by the state authorities. Only that
So
I want.
you have reinstated him?
Yes, we have reinstated him.
And he has not filed any contempt for the 75% arrears?
No, my lord, no contempt has been filed.
What do you say? He says only the state should pay the 75%. The school cannot be
in
asked.
this case, just now he handed over this interim application copy. They have not served the copy of the appeal memo.
Okay,
and
you say notice on the writ appeal as well as application for stay. Returnable. 8th February. Right.
My lord, item 4.
Limited to the question of notice limited to the question of who should pay the 75% of the wages of the pay of the back wages, 75% of the back wages of the two.
5.
5. All right.
My lord, item 54 not pressed, my lord.
All right. 54 is disposed as not pressed. All right.
Item 41.
Item 31, I'm for the appellant. Case has been admitted on 7/11/2019 against Union of India matters. In fact, because of my problem, I got the file just now. May I play taken up tomorrow or day after tomorrow? Any day matters may fix so that I will go through matters. I can be able to assist.
No, notice is gone or
notice matters. Yes, we have served the copy on 8/11/2019 to the Council, Additional Standing Council, Central Government Standing, Mr. Mahanti, Aravind Mahanti.
No, but today I don't think there's any. Only PK party will appear.
So then I have to file another copy, but I filed a copy on 8/11/2019 to the then matters Council, Assistant Central Government Council.
But today nobody is appearing, sir. None is appearing for the respondent. Although earlier, one Mr. A.K. Mahanti was appearing. Fresh notice returnable.
Would I serve the copy to Deputy Solicitor General matters? I think better.
Yeah, additional copy be served on Mr. P.K. Paddy Leonard, Deputy Solicitor General of India. 30th January.
Item 42. Item on 42.
No, 1 minute. 31st January. 31st January.
Forty-two.
43.
None appears dismissed.
Item on 43.
My lord, 43, I am on behalf of appeal and I am filing death chart. My lord, in this case, my lord, the Honorable Single Judge passed order under Annexure 16, ignoring the statutory provision, my lord, under OCS Act. My lord, the respondent number 4 was the original employee of the primary cooperative society, Boda Polosa Service Cooperative Society, in the year 1964. My lord, I have given death charge 11/9/1964. He was the employee of Boda Polosa Service Cooperative Society. My lord, in the 1980, the cadre rule framed under Annexure 2, they all the employees of societies came under the cadre rule, my lord. That cadre rule abolished in the year 2003, 20th/2/2003, Annexure 3, my lord. My lord, all the cadre employees came to the cadre rule, bank employee, as per the government policy, on 20th February 2003. My lord, as per the order of the government, the respondent number 4 joined in office on 12/11/2003, Annexure 6, my lord. He retired on 30th/11/2003. He has served only 19 days, my lord. My respectful submission, the Commissioner, Regional Provident Fund Commissioner, Opposite Party number 3, decided 16B proceeding, treated the Opposite Party respondent number 4 as our employee with effect from 11/9/1964 to 20th/2/2000. No, sorry, 30th/11/2003.
How long will this take, sir?
My lord, respondent number has served only 19 days.
No. How long will you take to argue this matter?
My lord, it is only 5 minutes, my lord.
We'll pass it over, then take it another board. Let's run through the list once. We have a long list.
My lord, in this case, registered cooperative society counter is essential because this is a policy decision case.
Not necessarily.
You are Provident Fund Commissioner. I respectfully submit that government and registered cooperative society may file counter. Policy decision will be decided. All the letters of a register and the government.
No, they did not file it in the learned single judge. Did they not file a counter before?
No. See, for which I file appeal, my lord.
No counter was filed before the
single judge. All right. Since no counter affidavit was filed by the registered cooperative societies before the learned single judge, a direction is issued to them to file their reply before the next date. It's on 6th February.
Item 44.
In this matter, 1943 million, I'm appealing for respondent not 3 million. So regional provident commissioner. What my friend submitted is not correct at all.
Next hearing, we'll take it on the next hearings. Right.
Item 44.
44 may be disposed of as not pressed, my lord.
Disposed of as not pressed. All right.
Item 45.
Item 45, my lord, no instruction.
No instructions dismissed.
I'm for the opinion of 5.
Item number 55.
146. Over.
46 to 53.
All over. 54 is also.
Item 55.
None appears.
Item number 56.
No, we could have kindly pass over one person. Item number 55 kindly pass over. Senior counsel are with what?
All right, 55 pass.
Item number 56.
None appears.
Item number 57.
57 might not maybe taken up next week because I have some throat problem.
All right. Transfer the petitioner is stated to be unwell. The 2nd February.
At number 58.
May please, Lordships. Lordships, in this matter, without issuing any demand order or notice, a bank account has been attached. And I have also submitted the copy of the screenshot that no order has been uploaded in the portal also.
No, Your Lordship, order has been passed, Your Lordship. Your Lordship, this notice which has been enclosed in this writ petition, that notice has not been acted upon, Your Lordship, that 74 notice. What happened here, Your Lordship?
You're serving something you've not served on the other side.
Your Lordship, sorry.
If it is not served on in the physical mode or registry post or in the portal, so how can it be served? So today in the launch hour also, I have taken the screenshot. There is no order in the portal. So what they have done, Your Lordship, that in creating a temporary GST and ID, they have uploaded the order and there was no information to the petitioner. So when the petitioner inquired after the attachment of
anyway, now there is an order.
That's it.
Now there seems to be an order.
Yes.
So you'll have to file an appeal.
No, without that, there is no remedy for the petitioner because that is not available in the portal. So he cannot go for appeal also.
Even Your Lordship, in the attachment proceeding, the petitioner has requested for personal hearing and personal hearing was afforded. And in the personal hearing, the order...
No. She says she can't file an appeal because
yes, I cannot.
Uploaded.
Your Lordship, that has been uploaded. That is in the site, Your Lordship. That is without uploading the order, Your Lordship, how the demand will be followed.
She says a screenshot which shows there's no order.
I have annexed in the annex.
You want to take instruction. She says the order is not there.
Your Lordship.
Let him take instructions.
No, Your Lordship, already 15 days have been passed. They have not taken.
Now you at least have a hard copy of the order. No, he has just served you.
He is serving upon me. But if it is not served up to the petitioner,
I know.
then appeal cannot be filed.
So let him
So-
take instructions. You say, although counsel for the department has produced before the court hard copy of the orders purported to be passed pursuant to the show cause notices issued to the petitioner after giving the petitioner hearing, Ms. Kananbala Chaudhary states on the basis of the screenshot obtained by her that till date, those orders have not been uploaded.
Yes, till date. To date, 1236 also, I have seen that there is no order in the portal.
In the portal paragraph, Mr. Mishra and standing counsel states that he has to take instructions.
Attachment is there, Your Lordship. So
within Monday, we'll have it on Monday. 31st.
Okay. 55 may kindly with this.
55.
Yes.
55.
Let's say find a list of dates have been given there. Just I'll report to some dates.
Who's for the other side?
Other side.
Mr. Vibhudendra Das.
State.
He was there, is it?
Yes, there.
First call, he was there.
Yes, there, very much there.
All right. You see, none is appearing on behalf of the respondent when the matter is called out. 16th February, interim order to continue. All right.
Yes, obliged.
Item number 59.
My lord, may I be excused, ma'am? The legal heirs has been duly informed that petitioner has died and they are required to file substitution petition in this case. 8 weeks time may kindly be given.
It's a 2008 CM appeal of 2008.
My lord, petitioner has been died in between and the legal heir has to be brought on record for disposal of the CM appeal.
No, what's a delay? There's also a delay in filing the CM appeal. This is a writ petition of 1989, sir. The CM appeal is of 2008.
Oldest writ
of delay. Delay of 13 years, sir.
My lord, petitioner has died in between.
Sir, you have to still explain 13 years delay.
I have no power at all.
Then why are you arguing like this?
As I have instructed.
No paper, nothing. Just like that, you're standing and seeking time. Please. There's an inordinate delay of 13 years in filing the application for recall of the order. The delay is extraordinary, has not been properly explained. Recall of the order dated. Order dated 28th September 1994, passed in OJC number 4310 of 1989. The delay has not been properly explained at all. And therefore, the court is not persuaded to condone it. NC number 8 of 2011 is dismissed. Consequently, CMAP 406 of 2008 is dismissed.
Sir, petitioner has been died, it may be mentioned.
It's all right.
Item number 60.
60, my lord, rendered infructuous on behalf of Mr. Patti.
Infructuous is disposed of.
Weekly list item 61.
May I please, Lordship? Hello. And allowed to do the matter in BC manner. So this is a PL related to the matter. The seizure of Telma 40 and Telma AM, a drug used by for cardiovascular disease like high blood pressure, used by accuse people, my lord. My lord, in this
All right,
case,
you say the petitioner's representations. This is to the CBI.
yes, my lord. My lord, because this affair given to the Purighat police station, my lord.
Then why are you
In
giving
these
to a
case, my lord,
CBI?
I'm coming.
Now
My lord,
the
in
matter
these
is
How will the
under
CBI have
investigation by
control of this?
My lord, I'm
police
coming.
department.
If
My
you,
lord, let me permit, my lord. In this matter, Bihar, Jharkhand, and West Bengal, 3 states are involved. Till yet, the Purighat police didn't find the manufacturing unit where these life-saving medicine are made. So Purighat police has not that much of inventory to reach near the manufacturer who are manufacturing these life-saving drugs. And when 3 states are involved, we cannot deny that more
who's
states,
manufacturing, sir? Who's manufacturing?
till yet they are not fine, mind. Only the distributor arrested.
Who is manufacturing?
That can police, the state can say, the police authority can say where the
Okay, who's distributing? Who's distributing?
4 person and 1 person from Goya has been arrested only to distributing these drugs, my lord.
Have you made those persons party?
No, my lord. I have made the drugs.
Sir, you're making allegations against persons saying they're distributing drugs which are not approved.
When the affair is,
you have to make them parties, sir, to the writ petition.
I will make party, my lord.
So you withdraw this and make them. You'll have to have proper pleadings for that.
I will
No. The parties against whom allegations have been made are not impleaded as respondents, as opposite parties. There is also no proper pleadings in respect of each of them. Consequently, the petitioners withdraw the present petition with liberty to file a proper petition in accordance with law. The petition is disposed of in the above terms.
Item number 62. Item 62. Item number 62.
Password was
Passed. Item number 63. Item number 64.
63. May I please, Your Lordship? This PIL is being filed in the interest of all the electricity consumers and people of Orissa for printing and issuance of energy bill in Oriya language. Lordship, it is humbly submitted that the government of Orissa have, for smooth distribution of electricity in the state, handed over the distribution of electricity of different zones to the opposite parties, and the opposite parties.
You first make a representation to them. If they don't agree, and then you come to the court. At least you make a representation to them, please.
Lordship, for the speedy disposal of the case and for the removal of the bottleneck, administrative bottleneck, this court is
there. The defect has not been removed. They pointed out the defect to you.
Remove, my lord.
2 defects are there. Defect number 6 and 22.
They have been removed.
Rule 8 has to be complied with. The Rule 8 of the PIL rules has to be complied with. You have not complied with that.
Next week, madam.
No, but how? Without making a representation, how will you? That defect cannot be removed. You have not made a representation, have you?
Lordship, they're taking so much time and then not listening to the people's devices.
You have to first make a representation. Then if they do not respond, then you can come to the court. That's the rule.
Yes.
Counsel for the petitioner seeks leave to withdraw with liberty to first approach the authorities with concern with a proper representation, and after following up on such a representation to seek appropriate remedies in accordance with law. As post office withdrawn with liberty is paid for.
64.
Same problem.
Item number 64, it is a PIL matter relating to protection of a historical moat in Cuttack city. Your Lordship.
Again, have you made a representation?
Your Lordship, Annexure 7 is the email representation.
7. At page.
Isn't there a news item that NGT says that there is no...
Your Lordship, NGT NGT has,
they have lost the case in NGT.
the ground is that NGT doesn't have the power to that because it is not environmental in concern. I have annexed the order also of the National Green Tribunal.
Lordship may kindly see the so-called representations at page 44 to 46.
Lordship, order of the NGTs has been specific page number 40.
27th September. And I don't know when, on which date my learned friend has filed the case.
NGT. This case has been filed on this Thursday. This Thursday.
So
We've not even waited for a month, sir.
Yeah,
not even
let the representation be disposed of.
No. I don't know whether it is. They have to make a fresh representation.
You make it in writing and not
In
just to
writing,
be
not
a ASI.
No, I have made
all the authorities here also.
I have made to be a district magistrate Cuttack.
No, the email is not to the district magistrate Cuttack.
Yes, your lordship, district magistrate Cuttack is in page number 43. Sorry, 44.
44.
Your lordship, DM Cuttack.
Okay.
This is not the way to file the representation. You have to come forward with a proper representation. And in a physical mode, you have to submit it. Then only this is...
Construction is going on by whom?
By actually, as per ASI, OP number...
The copy is also not given to us.
Today, OP number 5, Archaeological Survey of India.
No, construction is going on by whom?
Your lordship, ASI.
ASI is constructing.
Your lordship.
How can ASI construct? I don't think ASI is going to be constructing buildings.
Your lordship, as for the photographs I have annexed, they have page number 24. The ASI has given poster also that they are constructing. Page number 24.
Constructing what?
It's a passage type. Exactly the motive of construction is not known, but it is look like in passage.
I don't even know if you've got your facts correct.
I do. I have filed an RPA, but the RPA has not been.
Okay, you appear for ASI, is it?
Union of India.
Who's for ASI? You also,
My lord.
All right. An advance copy of the petition be served on counsel appearing for ASI to enable him to take instructions.
How would it go now?
24th November.
Deeply blessed.
Item 65.
None appears dismissed.
Item number 66.
3-day time remove the defect.
It's 21 matters, sir. What's the matter about? How is this a PIL? The sharing of it's a tax.
Yes.
That's what covered. I think. Correct. So this is already covered now by all this. You're asking for a passover?
My lordship, defect removed 3-day time.
But matter seems to be covered.
My lord.
It's already covered. So we'll dispose it off in terms of the judgment. No, this term with this judgment itself. Correct. No, but the prayer here is the same as this. In view of the judgment dated, in view of the judgment of this court, on this, is it? Harish and Maji. But there's no stay. In view of the judgment in Harichandra Maji versus State of Orissa, 2021 SEC Online Orissa 643, and the subsequent order dated 25th August 2022. In writ petition civil 14897 of 2021, bracket Deepak Kumar Das versus State of Orissa. The present writ petition is dismissed.
Item 67.
The demand on the basis of audit objection. And I have given a set of orders. One order to Lordship, pray for a mirror order to be passed in this case. Lordship has referred, and only the dates are to be changed, my lord.
All right, same order.
Only your Lordship may see the dates are there for filing of an representation to the state and disposal the targeted period.
And not later than we'll have to change that.
That's right.
Okay, 31st January 2023. What's the date of the demand notice?
Lord, the demand is dated 29th of September 2021.
Same thing.
Same.
So the revised dates are 23rd November 2022 for the reason order to be passed, and 30th November for it to be communicated. All right.
Ajay Lordship.
All right.
Item number 68.
May I please present? Here I've already served copies, my lord. The defect may kindly be ignored, my lord.
All right.
The facts of this case, my lord, is in this particular petition, I've challenged the virus of section 16(2)(c) of the GST Act, my lord, the OGST or the CGST Act. The facts of this case, my lord, is that the petitioner is a purchaser of medicines, my lord, from opposite party number 10. He has paid his due taxes to opposite party number 10, who has raised an invoice, my lord. Then, my lord, what has happened, my lord, due to the mistake of the opposite party number 10 in posting this transaction as a business-to-business transaction, he has done it to a business-to-consumer transaction. And that is why, my lord, when I claimed my input tax credit while filing my returns in GST 3B, my lord, it has been rejected because taxes have not been paid by opposite party number 10. Even though, my lord, I have paid those taxes to him. Now, my lords, a demand of taxes, interest and penalty, my lord, was raised. I went up in appeal, first appeal, my lord, and that was confirmed in first appeal, my lords. Number contention, my lord, is
the tribunal has not been set up.
Sorry, my lords?
That the further appeal, the tribunal does not exist.
It does not exist, my lord. And further, my lord, this particular provision of law, my lord, has brought in an onerous duty cast on the purchaser who has no control over the seller, my lords. And the seller, my lord, he gives a certificate that by mistake of my auditor, if your lordship would kindly see the certificate which has been given, that is also
notice go that there are no similar petitions.
No, there are many petitions challenging section 16(2)(c) of this. I'm sorry, I have not got the numbers of this.
Identical matters are pending, and today also one item number 85. In that case, counter has been filed, your lordship, and similar order may be passed.
Your lordship may kindly your lordship may kindly turn to page 61 for a moment.
Your lordship has admitted that matter.
No, I'm not aware of the order, my lords. Here, my lord, your lordship would appreciate in 61, running page 61, my lords.
Here the amount is 192 something.
My lords, what has happened, my lord? I have already paid 10% of that amount, my lords. And your lordship would appreciate, my lords, if a second appeal is there, my lord, I pay 20% more than of the balance amount, my lords. What my learned friend, lord, now the state can't have two sets of taxes, my lord. I have already discharged my liability so far as opposite part number 10 is concerned. The state, my lord, has received the taxes. The problem was, my lord, if your lordship would kindly turn to page 61, the opposite party number 10 says that it is my mistake. Instead of a B2B transaction, I've shown it as B2C transaction. But that does not mean that the state has not received its due taxes. Now, my lord, in addition to the taxes, I've been saddled with penalty and interest. The order which my learned friend
Pay the 20% at least then.
I'll pay the 20% of the remaining, my lord.
All right. You see, notice, Mr. Mishra accepts notice for opposite party numbers.
Let you and 3 I am appearing, Lord. Opposite party number 6, 7, 8.
And for 2 and 3, Mr. Satpathy.
I am appearing.
All right. And Union of India, Mr. Padi.
India, my lord, that's
subject to, you say notice will now go to opposite party number 9.
9 and 10.
9 and 10.
9 and 10. Right. Returnable on the next date. The tracking report will be placed in record. And in this IA 18450 of 2020, you say Mr. Kara informs the court that at the stage of the first appeal, 10% of the tax and penalty demanded have been already deposited.
Tax,
only taxes. 10% of tax has been deposited. Stop. Subject to the petitioner depositing 50% of the balance amount within 4 weeks. There will be no coercive steps will be taken against the petitioner till the next date. Okay, 20% bracket, inclusive of the 10% already paid.
Right. The language is 20% of the remaining amount.
20% of the remaining amount.
That's better. We leave it at that. 20% of the remaining amount.
20% of the remaining amount.
Right.
In addition to the amount paid.
That's what the section says. That's right. Correct. 20% of the remaining amount.
Remaining amount of tax.
Correct. Correct. Remaining amount of tax.
Quickly obliged.
Right. No coercive steps will be taken. List on 2nd February.
Item 69.
Similar also, my lords, sorry, my lords. Similar is also item 85. My lords, here I have already complied your lordship's order dated 28th of September 2021. The lordship directed that excluding penalty and interest, I'll deposit that amount. So that amount has been paid. So it may be tagged along with that.
Your lordship, in this case, item 85, we have already filed counter, your lordship.
Maybe.
My lord senior is to file rejoinder.
I may not file. Yeah, totally. Counter is totally bereft of merit. We have to the papers. Yes.
All right. So 85 also the same date.
Same date, my lords. And Union of India has to file because the
hires of that Union of India be filed within 4 weeks. Rejoinder for the next date. In 85, list on the same date, 2nd February. Interim order to continue.
69.
69.
May it please the lordship. Here, my lords, the petitioner before lordship is a victim of technical glitches of the computer. Whether the central excise of the central government, they floated a scheme. The scheme is likely that income tax scheme, Sabka Biswas label, dispute resolution label. Then, my lords, I applied. I also paid that amount. Now the bank, but because of the technique, I have given the details. Lordship will kindly see. At page 10, I have deposited that amount. It was to go to from the bank to the Central Excise Commissioner, my lords. Now, my lords, because of that, they have filed their counter. They said that in the counter affidavit, lordship will kindly see. So far as this aberrament is concerned, no comment. Para 4, my lords. They have said that we did not receive the payment. We have not received the payment. And if your lordship will kindly remember, lordship gave a judgment on 1st December 2021 on this technical glitch where the GST department did not restore the old number. And because of that, the petitioner could not carry forward the ITC. And your lordship said that technical glitch cannot stand as a bar to give substantial justice. That is Ashok Kumar Meher versus GST department. Here, my lords, for no fault of his, I deposited that amount, and because of the technical glitch, the bank could not transfer.
Previously, your lordship has in many occasions have already decided the case that they have to file it manually and it has to be accepted, my lord. If my lord senior is agreeing to that order.
All right. Why would he not agree? He wants your money to be accepted only.
Yes. Previously, many occasions your lordship has already directed.
Deposit karchi.
Deposit, it has been not received actually. On the next
you
page,
take instructions because he says he's already deposited.
My lord, on the next page number 11, if your lordship will come to page number 11,
yes,
the same amount has been credited back also.
Credited because of the fact that it could not be transferred. They have to credit it.
That's why I'm suggesting, my lord and friend, that if that manual, because that date has already been over, my lord. It cannot be.
All right, you can deposit it manually. Then if he's
manual, lordship may direct. As other, they will say again that manual is
the grievance of the petitioner is that on account of a technical glitch.
Within 4 weeks, lordship may kindly stipulate the
payment made by the payment in the sum of rupees 915,217.60 made by the petitioner pursuant to the SV LDRS -3 bracket rectified. In the SVL-DRS 3 rectified form has not been accepted by the respondent number 1 authority. Paragraph. Counsel appearing for the respondent 1 authority states that if the petitioner makes the deposit manually.
My lord, without recording my if your lordship will.
All right. You see, this court has heard the submissions of learned counsel for the petitioner and respondent number 1. So, considering that the technical glitch is beyond the control of the petitioner, the court directs that the petitioner deposits the aforementioned sum manually with the respondent 1 authority on or before.
May I suggest, my lord, the same amount, because again they will say that you pay interest because
the
2 years have
aforementioned sum,
lapsed.
The authority on or before 9th November.
9th November.
9th November, it shall be accepted by the authority.
And you will get a certificate because under that
certificate will be issued to the petitioner in accordance with law.
Much obliged, man.
The petition is disposed of in the above terms. All right.
Item number 70.
Unless the defect is 18I, I have already, that is annexure 1A, certified copy of the annexure 1A. I have filed a dispensation petition for dispensation because annexure 1A has been filed with the first appellate authority. And I have filed the appeal order original and filed the attested true copy of the order as annexure 1A. That may kindly be dispensed with.
This font so tiny. Just show me the original. How is this not Marcus? Sir, this kind of font, are you able to read? The font you have chosen to type the applications.
Well,
are you able to read it?
Sorry, madam.
No, I don't know how they did not mark a defect. Very tiny font. Yeah. Yeah. What is the, there must be similar matters. This again, because the tribunal has not been set up.
My lords.
No, let's see, your lordship, tribunal is not there, so let it be admitted. But here, your lordship, the issue is something different, your lordship. Here, the issue is something different. So far as the CIRP proceeding, your lordship. So the petitioner here challenges the adjustment of refund against the demand, your lordship. Your lordship, here, the demand as well as the refund, both are prior to commencement of CIRP proceeding, your lordship. Both are, your lordship. The demand is with effect from 2010 to 2015, and the refund is with effect from 2017 and 18. Here, your lordship, the CIRP proceeding has been commenced with effect from 5th March.
I don't think he's asking for interim order, is he?
Your lordship, may I admit you.
He says notice, he accepts notice. The registry will ensure that the petitioner, you say counsel, the petitioner undertakes to refile the entire petition in font as has been prescribed in the meanwhile. Say, replies be filed within 4 weeks rejoined of
your lordship. In absence of the tribunal, your lordship may kindly note, in absence of the
petition is being entertained only because the appellate tribunal, the second appellate tribunal has not yet been constituted. And then you say this. 1st March 2023.
Item 71.
Same.
Same.
Item number 72.
You have to serve a copy on the other side?
I've served a copy to open the statement.
No, not serve.
I will serve a copy.
Not serve.
Defects be removed within a week, list thereafter. Both matters, 72 and 73. Right.
Item number 74.
74.
No instructions. No instructions dismissed.
I am there.
Item number 75.
75, my lord, lottery matter covered by your lordship's judgment dated.
This is the infructuous.
Yeah. What happened to these matters? They went to the Supreme Court, right?
No, that interim order was rejected. Then it is final hearing. I think it is pending.
It's pending. Okay. In view of the judgment of this court, dated 29 January 2021.
Already 2 years passed in the meantime, only 3 years more.
Petition civil 1076726 of 2021, bracket Naveen Kumar Singh versus State of Orissa. The present petition is dismissed.
Wiki list for admission, item 76.
76, my lords, last at my lords, director municipality to serve counter. Just now they served the copy of the counter, my lords.
Counter is ready, my lord. I am filing it today, my lord.
All right.
I have copy number 5, your lordship. They also have a copy on you.
All right.
Counter, my lord, may be taken on record, my lord.
The counter affidavit of the Berhampur Municipal Corporation.
The opposite party number 5.
Bracket copy number 5 is taken on record. Copy thereof is served on counsel the petition as well as
OP number 5.
Petitioner, I have served. I will give a copy to OP.
I have received it.
As well as OP number 5. All right.
Interim order to continue.
Interim order to continue. It's on 1st March.
Item 77. Item number 77.
Nana, please. One minute.
No,
letter,
this is
Sambalpur DLS in a letter. What's this?
This is that PIL, my lord. On the basis of the letter, the DLS has given its report. And we have also filed the counter affidavit.
SN Mishra last time.
78.
77.
No, 78.
So last date,
77 last time one Mr. SN Mishra appeared.
Your Lordship has directed the legal service authority to appoint his lawyer, appoint a lawyer. Right.
That legal counsel to make submissions. Not turn the whole side. Last time he appeared. Notice with the process will be issued to Mr. SN Mishra, advocate, appearing on behalf of the petitioner who is not present today, requiring him to remain present at the next date. 16th November.
Lord, Lord, kindly see para 2 of my counter affidavit. This land has been.
I know already.
A company, namely Bishaka Industries Limited.
Correct.
Better, your Lordship may issue notice because the land is under their possession.
No. This was the prayer made.
Yes, my lord.
This is not the factual thing. In fact, para 4, he says the land is still existing as the full plot has not been fragmented.
During the consolidation operation, they did not approach the appropriate.
Correct. So let's say we just gave one opportunity to the counsel, the petitioner, to examine this affidavit and make submissions.
Okay.
So we're issuing notice to him without process fee now. All right.
Item 78.
In 78, may I play this matter may be taken up next week, my lord. I'll file a short counter in the meantime.
All right. At the request of Mr. Kuntia, learned counsel appearing for the respondent, who states that he will file affidavit before the next date.
Right.
9th February. 9th February.
Item 79.
79. This matter. Here is a petitioner who is imparting training to unarmed security guards by virtue of a scheme floated by Government of India, and that is directly under Ministry of Skill Development and Entrepreneurship. And they have a guideline of version 1.0, which has to be followed for these accreditation, affiliation, and continuous monitoring of training centers. And the two agencies, implementing agencies under the said central government authority, both again, they are also the same. That is NSDC and MEPSC are implementing authorities, agencies, directly under control and governed by MOSDC. So what has happened?
And this petitioner's training center is a registered training center on the web portal of SMART and SIP. Registered. And both the training partner as well as the training center, both are registered. For the academic year 2020-21, we started the process of yearly approval, accreditation and approval or affiliation. And on 14/3, everything is being done through online. Entire process has to be done through online. So this, I have given a relevant list of events.
So anyway, your re-accreditation request has been rejected now.
Rejected because what they have done, I have followed the entire process, inspected, everything done as per law.
Just issue notice. All right.
No, notice has been issued. And your Lordship were directed to serve copies, which has been done on last occasion.
Who's appearing?
Debashis Tripathi.
My lord, I am appearing for Union of India, OP number 1, my lord.
Other
party not.
I think.
What happened to your reply? Have they all been served?
Yes, my lord.
Have they all been served, sir?
Copy served, and I think on the request we've served to all the opposite parties as order is there. Lordship Miss C.
No, serving is one thing, sir. Not.
I have served on all, and they have accepted it.
One to 5.
Yes.
What happened to your reply, sir?
Only, my lord, I am appearing for OP number 1.
But notice was accepted on behalf of 1 to 5 last time.
In this regard, I have taken instruction, my lord.
Sir, you have to file your reply.
Yes, my lord. After 1 week, 2 weeks after, then I have to reply.
The last opportunity is granted. You were already given 4 weeks time last time.
Yes.
Last opportunity is granted to the respondents to file the replies within 8 weeks, rejoined for the next date. January 31st.
First of January.
Item number 81.
Which can I know the date?
31st January 23. Item 81.
Can I pray a bit earlier, my lord?
Yes.
81.
Man appears dismissed.
I am for the opposite party.
Item number 82.
Here may I please your lordship. Here may I only pray for Monday. I'll file the rejoinder by tomorrow. There was some difficulty. I made it ready. I couldn't make it filing. Only praying for Monday, my lord. I'll file it by tomorrow, my lord.
What's the urgency?
This is regarding a new sand soil source which has been created without having adequate road and everything. So the villagers have come up. Only I'm praying for Monday, man.
No, 1 day is not possible, sir. We'll have
As your lordship pleases, man.
Rejoinder will be filed for the next date. 13th December.
I'm obliged, man.
Item number 83.
83 that relating to fixation of high security number plate. Last occasion of lordship I have submitted, and in the meantime, all the Jana Sabha Kendra and Mo Sabha Kendra in the state has been operational for booking. That apart, my lord.
What is the revised deadline now?
Lord, 31st October in respect of registration number ending with 1, 2, 3, and 4.
Your Lordship, I'm submitting a copy of the communication by the State of Orissa to the Transport Commissioner, dated 6/10/2022. That is after this revised dates has been issued by the opposite party number 2. And your lordship may kindly refer to the third paragraph. In view of above, you are requested to assess the number of old vehicles, the capacity of HSRP manufacturers to prepare and affix HSRP in a day, and calculate the time required to affix HSRP in all such old vehicles and refix the timeline accordingly after due approval by government. Steps may also be taken in consultation with HSRP manufacturers for fixation of HSRP in vehicles whose original manufacturers have closed down their business in the meantime. So, your lordship, in the meantime, this has come after your lordship has directed for revising the timelines. And your lordship, the revised timeline is until 31st for the number ending 1, 2, 3, 4.
So there is absolutely no difficulties for the people now. If necessary, if there is any difficulty, the state government will approve the extension of time with after submission of a report to the government by the Transport Commissioner. That is the letter.
Also,
Your lordship. But the deadline, if we say, is 31st October, which is just 3 days.
Yes, so that is with regard to registration number ending with 1, 2, 3, 4. We have to work out the total number of vehicles
available. As of now, until December, no slots are available.
Yes, the slots are available now.
No, your lordship, it is not available.
What my learned friend is submitting is incorrect.
Your lordship,
all the
it's not available. One is not available. It is not available, your lordship. If it is available, let them say so on the affidavit.
Yes, my lord, I will file it. That apart, my lord, all the 38 RTO offices and ARTO offices has been utilized for booking through the OEMs. Lord, there is absolutely no difficulty for the people for booking. So far as number of vehicles and if it is necessary for extension, Lord, that data will be provided by the Transport Commissioner to the government and government will extend the time. Lord, I hope.
When will it take the decision? No slot booking till December.
That is
also, your lordship, with that memo, I have filed one notification of the central government that was issued clarifying, your lordship, the procedure in which the number plates that are issued, how they will be dealt with in case there is any breakage, in case it is damaged. So our notification dated 26th May, which is the impugn notification here, there is no such specification. The notification only says that upon application and affixation of such number plates will be penalized for 5,000 or 10,000. There is no such specification if it is a one-time thing or it is going to get repeated. And on the last occasion, your lordship was inquiring about this penalty that is said to be automatic. So again, on that, there is no clarification by the State Transport Authority, your lordship.
Lordship, kindly see the last instruction that is there. Lord, even after expiry of the revised deadline, enforcement of HSRP will be done manually, not through camera and cameras at least for 6 months.
But if somebody does not have that HSRP, he'll get penalized even manually.
Yes, yes.
If there is no slots available till December.
Lord, there is apprehension that the vehicle will caught by cameras and automatic.
Not only camera, any prosecution, even manually. Suppose the policeman waves down the car, and the person has tried to get online to apply for the HSRP and no slot is available. Then what is that person supposed to do? So the petitioner has placed before the court a memo
enclosing the copy of the affidavit. So
a news article that appeared on 29th September 2022 in Samaj, inter alia stating that no booking slots for HSRP plates online is available till December 2022. She is also placed on record copy of the instruction dated 21st October 2020 issued by the Ministry of Road Transport and Highways, Government of India, to all state transport commissioners regarding replacement of HSRP in case of damage. Full stop. It is pointed out that no such instructions have been issued as far as state of Odisha is concerned. Paragraph. Counsel for the Transport Commissioner for the respondent department undertakes to file an affidavit on both the aspects. When will you file it? By 31st? We'll have it on 31st.
Yes, my lord.
Lordship, the timeline may be extended and they may be.
Well, Lordship, call this matter 31st.
Yeah, on 31st. By on or before 31st, list on 31st. All right.
Lordship, may kindly direct to take it up at 10:30 a.m. because that is the last date.
At 10:30 a.m. All right.
Obliged.
All right.
I may be pardoned, my lord. Extremely sorry that I was not there when called item 81. The Lordship may take it up on 31st also. My lord, this is, let it be hard and dismissed. That's what non-affairs and dismissed. My lord, let it be.
All right. 81, you say list on 31st.
My lords, I'm sorry, my lords. Item 45, I'm opinion number 5. Advocate for the petitioner submitted no instruction. And my lords said it was they had obtained a stay order. And I have given the order that may be vacated. My lord,
all right, interim order vacated. All right.
Vacated may not be.
Item 84.
Your Lordship, item number 84. This state revision, your Lordship. Your Lordship, this revision has been drafted. This revision has been drafted and filed by my Lord Justice.
I know he mentioned. Unless if you has an objection.
I have an objection. We are completely.
Yeah.
Your Lordship. Your Lordship, in this case, the question of law is at 26.
On the last occasion, after the matter was heard, I lost my file in this court. Just now, I have got a copy from him. Let me add to some of that so that I can.
Right. At the request of Mr. Sarangi, the counsel appearing for the respondent. Some difficulty today. Let's go. How long will this take? How long will the matter take?
Very small matter because there are two contrary orders. One here, here department has challenged the division bench order.
29th November. 29th.
All
right.
Item number 86.
Item number 86, I may pray 4 weeks time for filing of counter.
This is already this is a covered matter, my lords. Here the issue, my lord, is whether interest should be paid after this. Your lordship would appreciate that this is such a.
The covered has been decided.
The covered
that aspect your lordship admitted.
The covered matter has also been taken care of. Your lordship would appreciate that the Supreme Court order is a surcharge matter, my lords. The Honorable Supreme Court's order is 28th of October 2016, my lords. And the recomputation order is 16/8/2017. And I paid the entire taxes as on 4/2/2017, much before the recomputation order, my lords. Your lordships in this particular covered matter, if the lordship kindly see, after all the cases following Food Corporation of India, your lordships have said that after the Supreme Court's judgment and detailed demand notice has been filed, it's the same petitioner, my lord. It's the same petitioner which is before your lordships. Your lordships have taken note of section 413(4)(f) and 13(6) of the Odisha Sales Tax Act, which provides for issuance of a demand notice. And if a demand notice is not complied with, then interest will be leviable, my lords. And here, my lords, if your lordship would, on the face of it, my lord, your lordship would see, well, page 22, which is a part of Annexure 1, my lords. If your lordship would see the table, my lords, the first, your lordship got it, lords?
Yes.
If your lordship would see column 6, the first payment was made on 1/5/2003, and the balance amount was paid on 4/2/2017, my lords. So this recomputation order after the Honorable Supreme Court's order was dated 16/8/2017, my lords. And your lordships have taken care of these two aspects, my lord, have followed Food Corporation's case, my lord, in this case, and your lordships have quashed the levy of interest.
Your lordship might have remembered, your lordship may kindly turn to the last order on dated 9/9/2021. Your lordship has allowed all the cases. Your lordship has disposed of all the cases except this case. Your lordship, because
complete. because my learned friend said that he wants to file a counter.
No, Your Lordship. Your Lordship has admitted this case and issued notice since no consequential order pursuant to Honorable Supreme Court's order has been passed, Your Lordship. And except this case, all the cases have been disposed of.
Anyway, we granted you time on 16 December.
Your Lordship, I'm sorry. Your Lordship, don't try to respect. I'm sorry.
The last
occasion. Your Lordship, only last chance. 4 weeks time began. 3 weeks time may be granted, Your Lordship, on the last chance.
All right, as a last chance, reply be filed within 4 weeks, rejoinder of the next date. List on.
So these two orders may be kept on file.
Yes, yes.
I may kindly be permitted to mention, Your Lordship.
1 minute, 13th December. Interim order to cut.
Your Lordship kept it the 13th.
13th December.
Regular pledge.
Sorry. Item 87.
There are also several technical glitches in the HSRP matter, Your Lordship. I'm mentioning in the HSRP matter.
Where is he? He's there.
For one instance, I can show it in my phone.
It's already 31st. It's coming up.
It's just that, Your Lordship, since they are filing the affidavit, on the last occasion they submitted that all the development infrastructure have been taken up. So let them also place a clarification on what has been taken up.
Yes, my lord. That affidavit I will write.
All right. All right. Item 87.
May it please your lordships. My lords, this matter, my lords, is squarely covered by the judgment of the Honorable Supreme Court in Union of India versus Ashish Kumar Agarwala. The first one is, that is 38822. There are two notices under section 148. Annexer 1 and 2. One has been issued on 31st of March 2021. Then without withdrawing that, a second notice under the same section was issued, that is on 8/4/2021. Now the department has filed a counter affidavit saying that they have got the jurisdiction to issue that notice because of the Relaxation Act, Direct Tax Relaxation Act. My lords, your lordship has taken notice of the judgment of the Ashish Kumar Agarwala case, and in Nutan Kumar Jena's case, lordship have fully discussed the judgment of Ashish Kumar Agarwala and said that, lordship said that the Ashish Kumar Agarwala case said that any notice issued after 1st April 2021 will be deemed to be a notice under section 148 and he has to follow the formalities. And that has not been done. Now, certainly the CBDT instruction or the notification relaxation cannot override the judgment of the Honorable Supreme Court delivered in Union of India versus Ashish Kumar Agarwala, reported in 444 ITR page 1. I am giving also those judgments, my lords. And also in Nutan Kumar Jena's case, that will take care of item number 89, where the assessment year is 13-14. And
Let's
6.
kindly take a one by one because
One by one. Yes. Certainly. One by one, yes. First one is, my lords, 38822. Assessment year is 16-17. 4 years lapsed. I guess your lordship is not tired.
You guessed right.
Then your lordship may
We'll take it up tomorrow.
Tomorrow, yes. All the three matters, matters. What I pray, if your lordship will be pleased enough to take up item 87 and 89. Sorry, 89. Item number 87, 88 and 89. Right. If your lordship is otherwise not inconvenient, what I pray, my lords, and once again, my lords, belated Happy Diwali to your lordships. And while I noticed, my lords, after Justice Raman Mundan, he looks very cute. His lordship looks very cute.
All right.
Once again, my lord, belated happy Diwali and let the rejoice.
Yes, yes.
And also
To all of you too.
Thank you, your lordship.
So tomorrow, 87 to 89 tomorrow.
Item number 90.
87, 88, 89, 89. Nah?
Yeah, 87 to 89. All
Yes.
three. Tomorrow.
Oblige, my lord.
Right.
Item number 90.
May I please, your lordship? Lordship, sir, I took 5 minutes, my lords. May I permit, my lords?
No, notice is gone or not gone?
Yes, yes. Lordship, counter affidavit has been filed by the revenue, my lords.
All right.
This is a squarely covered by a GK and website, my lords. Reason recorded for reopening and copy of approval has not been submitted, provided to us prior to completion of reassessment proceeding.
So we'll take it up in the early date. You're not filing a rejoinder, right?
No, no.
All right. Pleadings are complete. List on. November 15th.
Interim order continue.
Interim order continue.
Yes. Okay.
Pastor matter, item number 3.
May I please, your lordship? Item 3, I'm appearing on item 3, my lord. My lord, here I am challenging the show cause notice. The impugn notice is under Annexure 1, page 9, my lord. My lord, we had filed an additional affidavit, my lord, and my learned senior had also filed a counter. We had received it. They were seeking time for the FCI to file the counter, my lord. I would just like to draw your kind attention to Annexure 5, my lord. Annexure 6, my lord. The matter is regarding storage loss, my lord. And for that, my lord, the warehousing corporation had written...
Complete.
My lord?
I said.
First of all, lordship, my counter has not come. That's why lordship directed to.
My lord, yes. The counter was not on record, my lord.
Just, yeah. Here, this also. We'll take it up on another day. It's already 4:30.
Lordship is looking at.
Yeah, the affidavit of the OSWC.
State warehousing.
Next week, my lord?
What's the hurry here?
No, not
My
here.
lord?
I need a lordship.
My lord,
What is the hurry? What is the hurry?
My lord, the problem is, my lord, illegally they have recovered the amount that has been impugned in the Annexure 1 from my CPF dues without any notice whatsoever.
All right. Take a chance on 29th November.
My lord. Highly obliged, ma'am.
Pastor matter, item number 34.
May I please, my lord. Now, this is a case where I have lost my remedy of because I preferred a writ petition instead of preferring an appeal. And the background is like this. And the respondent number 4 was appointed instead of me. So Anganwadi worker. Now I got material through RTI Act that he has forced her mark sheet to show it more than my mark sheet, and as a result of which she got it. Instead of filing an appeal, I filed a writ petition for this noble court. This noble court was pleased to direct that the CDPO should consider my representation with regard to this forgery part of it, my lord. Now the CDPO did not take a decision on my representation for a considerable length of time. I did an appeal, because an appeal is provided for in the, my lord, Anganwadi workers guidelines before the learned ADM Kendrapada, and that is the forum to prefer an appeal. Now the learned ADM entertained my appeal and deferred the case from time to time. I have quoted it in page 4 of the appeal, paragraph 4, my lord. After deferring it for a certain time, at page 12, annexure 2, your lordship will kindly peruse, the ADM says this, since there is no order of CDPO to challenge, the appeal is not maintainable. The appeal is maintainable against the very original order of appointment. So therefore, that is the guideline, my lord. So therefore, this was a misconception that appeal is not maintainable. I moved the Honorable Single Judge. Honorable Single Judge also was pleased to observe that since there is no order of CDPO, so therefore the appeal was not maintainable, it has been confirmed. The only mistake possibly was filing the previous writ petition directly before this noble court, wherein the CDPO was directed to consider my reprehension. Now, even till today, your lordship will kindly see page 12. The ADM is also a superior.
You've not had a proper forum yet. You have not got even one forum yet where your appeal can be considered.
But that is the difficulty. And against the original appointment order, the appeal is maintainable. So I prefer an appeal for the appellate authority. One more thing, irrespective of whether CDPO decides it or not. So therefore, my lord.
It's an appointment of which year?
My lord, that is true. My lord, I am conscious of that. This is of 2011. But only thing your lordship will consider, can a person, has it been a case of merit? That is different. Can a person be allowed to continue on the basis of a forged document? That is the only point, my lord.
And your 45 years.
I have been deprived of. I am also interested.
No, what's the ultimate age?
My age now?
In 2018, you were 45 years.
Yes. That is true.
And
but
now,
that is I was within the qualification.
No. Today you can't be appointed anyway. How can you be appointed today?
It will be only a case of if I have been illegally, because if your lordship interferes with the appointment of a respondent number 4, your lordship, the appellate forum, if it is relegated, then certainly I will get the post because
your age. What's your age?
I'll not be disqualified because my appointment will relate back to that stage. May not be with higher pay.
Sorry, sir. No, it won't relate back. How can it relate back? Your age can't relate back.
My only thing
What's
is that
the upper limit age?
44, I'll just
44.
Yes. No, one thing your lordship will consider.
No,
but for the fact that this forgery document,
whatever,
had it not been
you can't get relief anyway. The appellant being already well over 45 years on the date of filing of the appeal cannot hope to be appointed as Anganwadi worker even if she succeeds. Consequently, the court is not persuaded to interfere. The appeal is dismissed.
I'm obliged.
Item 62. Item number 62.
None appears despite the passable. Dismissed. That's it. All right.